I'd like to mention item number 5, my lord. This matter may kindly be taken up after 3 weeks, my lord. Item number 5.
No. Wait.
Lordship, here, my lord, we might require to file an additional affidavit, my lord.
No, we'll see. Let us see. We'll see. There's no question of addition. Yes.
I beg to mention item number 50, my lord.
Huh?
Beg to mention item number 50, my lord. 50,
50, yes.
my lord. Maybe taken up, my lord, after a week, my lord.
After a week.
My lord.
What is the matter about?
My lord, regarding the new pension schemes, I'm claiming old pension.
On the prayer made by
R. Sharma.
R. Sharma, the counsel for the petition. This is the matter after a week.
Okay.
I beg to mention item number 53 of supplementary list, my lord.
53.
Yes, my lord.
Yes.
Matter will pass off for a day, my lord. 53.
Okay. On the prayer made for adjournment by Mr.
K. Kolita.
K. Kalitalan, counsel for the petition. This is the matter after a week.
May I please, your lordship? I beg to mention item number 47.
Yes.
We will file a reply affidavit, but the petitioner has some medical issues and she is out of Assam, so needs more time.
Okay. Miss
B. Talukdar.
P. Talukdar. B or P?
B.
B. Talukdar, learned counsel for the petitioner. Submits that affidavit in reply could not be filed by the petitioner as she is out of station due to medical problems.
That's it.
Accordingly, this matter after
3 weeks.
3 weeks.
Highly advised.
May I please beg to mention the listing of the matter, contempt matter for orders. Matter relating to family pension matter. Since 2014,
We were there.
on 22nd, lordship.
Huh?
22nd of November, lordship. Wednesday, lordship. Okay.
24. 24. 24.
May I please, your lordship? Lordship, I beg to mention item 22.
Yes.
22. Lordship, we have taken the consent of the others, both the learned standing council. Subsequent development has taken place, Lordship. We need to file an additional affidavit.
Your father?
Petitioner, Lordship.
What is your name?
S. Dev.
Miss S. Dev submits that some new development has taken place and an additional affidavit needs to be filed.
3 weeks time.
Accordingly, please for 3 weeks time. This is the matter of the 3 weeks. If praise allowed, this is the matter of the 3 weeks.
Lordship, a date may be given, 14th December. Lordship, there's another matter, item 44. That matter, Lordship, some service is not complete on respondent 9, as complete address was not given. So this matter has come up on Lahojima Court. So I've appeared on Lahojima Court and it was again to appear on 8th of this month in November. So I missed that to appear before that court. So it has come up again here. So recently we have taken instruction from the petitioner. So she was not well these days. So now she is ready to give the complete address of the respondent 9. So we'll take the press steps on respondent 9.
Your name is not here.
It's an old pending. It's not.
Huh?
It's not there. My name is not there. I'm representing Mr. M. Datta.
Miss S. Dev appearing on behalf of Mr. M. Datta submit that the petitioner will give the correct address of the respondent number 9 to the registry and take steps for service of notice upon the respondent number 9 within
In 3 weeks time, Lordship.
or 3 weeks again.
Take 2 weeks time, Lordship. 2 weeks is
Huh?
2 weeks.
Just give me this item 44. Two weeks time is granted. This is the matter after 2 weeks.
Oblige, Lordship.
May I please, your Lordship? Lordship, I beg to, with the consent of others, I beg to mention item number 15, 16, and 18. The Honorable Court asked me to file affidavit in opposition, my lord. I am appearing on behalf of Education, Elementary Education Department. Affidavit is ready, my lord, and we file
15, 16,
and 18, my lord. These matters are relating to my lord and
salary,
my lord,
payment of salary.
my lord. So, my lord.
Where is the petitioner's counsel?
I am the petitioner in the item number 16, Lordship.
Okay. So any objection?
No, it is only fix the date, Lordship.
Okay, Mr. What is your name?
B Talukdar,
B. Talukdar appearing for the
Elementary Education.
Elementary Education Department submits that he has received instructions and will be filing affidavit in a position within
1 week, my lord.
within 1 week. List the matter on
Oblige.
15, 16, and
18.
18.
May I please, Lordship? I am bringing for listing of a case for motion on Monday, Lord. Oblige.
May it please, your Lordship. Lordship, I beg to mention item number 37, Lordship. Matter may be adjourned for a week, Lordship.
Why?
No, senior has some personal difficulties, Lordship.
On the prayer for adjournment made on behalf of Ms. K. Devi and counsel for the petitioner, this is the matter after review.
Item 1, 2, 3, similar matter.
What is your case?
Lordship, non-payment of area salary.
For which period?
Lordship, from the date of completion of his training, Lordship.
What training?
DLS course training. Lordship,
I'm making, I can't understand what you're trying to say. Read your para 4 and 5.
Petitioner state that after joining his service, he has received his monthly salary from 1/3/2012 to 28 to 2017 at the rate of 1800 fixed pay.
So you have been receiving a monthly salary from 2012 to 17.
Let's come to page 9. This order.
No, you see one thing,
Look.
your para 4
Look.
says that you have been receiving a salary from 2012 to 17.
Look.
Now come to your prayer.
Okay.
In your prayer, you want regular pay scale from 14 to 17. Now,
10/1/14.
Huh?
10/1/14.
whatever it is,
This period Lordship not paid regular scale of pay. Lordship.
why should you be given regular pay, scale of pay?
He has completed DLS course Lordship 10/1/2014. Lordship.
Okay, he has completed and
From
so from that day you are supposed to get regular pay scale.
Lordship, page 9 it is clear that
Page 9.
Lordship, Lordship, in exercise of power conferred upon the Director of Elementary Education Assam by the government by letter number so and so, pursuant to the government letter number so and so, in continuance of government letter number so and so, such a following drop teachers are hereby regularized against the vacant post of assistant teacher of lower primary school in compliance of the Honorable High Court order in which case number so and so so and so, WC number so and so in the fixed pay of 1800 per month till the successful completion of diploma elementary education. Till the,
So where does it say that after you complete your diploma,
that's it.
you will get pay scale? Where does it say that?
That's it. Till the successful completion of diploma in limitation 800. After you will get the regular pay scale.
Where do we get that?
This is the thing, Losip. Till Losip successful completion of the diploma. Means after completion, he will get Losip regular pay scale of
Yes,
Otherwise, he's entitled to get the regular pay scale after completion of the that is
the
there, though it is not expressly
provided.
provided in the order, madam, but that is the procedure, madam.
So why is it not being given?
So, madam, may issue short notice. I'll obtain instruction, madam. Both the three cases, madam.
Right, heard, Mr.
L will.
L. Gogoi, learned counsel for the petitioner, who submits that though the petitioner completed his D full stop EL full stop ED course on 10/1/2014, comma, he has not been given the regular pay scale with effect from 10/1/2014 this 10/1/2014 and has instead continued to be given the fixed pay of rupees 1800 per month. Correct? Mr. N.J. Khataniar, you were supposed to obtain instructions on the last date also.
Last occasion, one of my colleagues,
It's
but
possible to
till this,
dispose of the matter, verify the department.
I think better. Yes.
that can also be done, madam.
What have I said? Just read. Okay. Just right before that, you're right. The petitioner's case is that in terms of the order issued by the Director Elementary Education wide memo number EPMD/LP/6/2011/187 dated 14/7/2011. The petitioner, this is a page 9, huh? Right. The petitioner was to be given the fixed pay of rupees 1800 per month till successful completion of the diploma in elementary education under Golaghat district. Correct?
Yes.
Under Golaghat. Good, sir. Thereafter, on successful completion of the diploma elementary education, the petitioner was to given the monthly pay scale of how much?
1800 per month. Plus up
No,
to-
no.
The regular
pay
scale of pay, madam. Regular scale of pay.
Was to be given the regular scale of pay.
plus
Regular scale. Good, sir. However, but then we put that, huh? Good, sir. The petitioner now submits that the present writ petition can be disposed of if a direction is issued to the respondent number 3,
Madam.
bracket director, to ascertain whether the petitioner who is working as assistant teacher in Babijaya LP School Golaghat has successfully completed the diploma course in elementary education on 10-1 to elementary education to start. If the respondent number 3 comes to a finding that the petitioner has successfully completed the diploma in elementary education, comma, the respondent should pay to the petitioner the monthly regular pay scale as is entitled to an assistant teacher. Next part, Mr. N.J. Khatane, the learned counsel for the Elementary Education Department, submits that he has got no objection to the prayer made by the petitioner's counsel. Next part. In view of the consent of the parties, the respondent number 3 is directed to verify whether the petitioner has completed the diploma course in elementary education, bracket, elementary education. And if the same is found to be in the positive, is found to be correct, the respondents shall pay to the petitioner his monthly regular pay scale as per his entitlement from the date he completes the diploma course in elementary education. The entire exercise should be concluded by the respondent number 3 within a period of
2 months, man.
what 2 months, right? 1 month.
Here,
From,
here are 3 petitioners, man.
Huh?
Three petitioners, man, in their total.
How does it matter? So difficult. Just look at the certificate. Within a period of 1 month from the date of receipt of a certified copy of the sum. Acha, okay. You just say Mr. N.J. Khatania, Learned Counsel Elementary Education Department, and Mr. A. Chaliha, Learned Counsel for the Finance Department.
Oblige, Judge.
Same as
2 and 3, but but the school will be school name will be different. Give me item 2. Assistant teacher, no?
assistant teacher.
Then out here, same date you finish the course,
No, same day,
same date,
same day. That's it.
except that you are a teacher in
Joy
Joy
Puri.
Pukri LP
LP
School, Golaghat.
No,
Golaghat, my father was the SDO, long time back. 1961. SDOC.
item number 3.
Item number 3, he was assistant teacher in Duria LP School, Golaghat.
10 long, Dodia
Huh?
preschool.
Number 10, Uriel.
Number 10.
Number 10 long. Dodia LP
Just
school,
enough.
Gulas.
Number 10, Duria. She will check.
Item 3. Oblige.
Yes.
Maybe, yes. Malata, last occasion, Malata, instructional short code from the department. Malata.
So your basic case is that the transferring authority has got no power.
Right.
That is your case.
That is.
Otherwise, lordship, the order itself speaks lordship is a very most temporary because genuine reason. On the genuine
No,
reason,
I'm not on that.
lordship.
What he is saying
Lordship.
is that the transferring authority, the person who issued the transfer order
DO is not the
has
transfer.
got does not have the authority, power. Is that correct?
Lordship.
Huh?
Subject to approval. If the approval is
So has the approval been given?
that instruction is awaited, lordship.
You obtained instruction.
Lordship, I will obtain
When? You ask now.
lordship.
If it's then otherwise we set it aside. Why should we wait just for that?
Only because of due to shortage of the science teacher in that particular school, he has been most temporary.
Whatever.
Lordship.
So how does it, you see,
Lordship.
the issue is this. If a person doesn't have the power or authority
Lordship.
to issue an order,
Lordship.
then that
I will whether the approval has been sought for, I will approve. I will
We'll take it up at 2. You find out.
Lordship.
Oblige.
Lordship made business number.
Yes, ma'am.
That is, my lord.
Yes, what is your prayer?
My prayer is, your lordship, I have challenged an order wherein our request has been rejected by the APDCL. Page 68, your lordship.
Your request for what?
For one-time
Regularization.
consideration in terms of honorable court's order. Lordship, because there are a series of petitions filed by this honorable, filed before this honorable court.
So,
I have also preferred
yes,
one.
what is the reason that they did not, they rejected your
Lordship,
prayer?
that they don't have financial strength to accommodate so much of
No,
persons.
besides that,
Lordship, and I have not completed.
10 years.
Yes, no. For 10 years, different order. And for those who have not completed 10 years, different order, one-time consideration.
No, you see, madam, it's like this. As per, you have got to complete 10 years of service. That is one.
Yes,
If you do not complete 10 years of service, then the minimum pay scale.
yes.
If you are working. Now, the first thing is, have you completed 10 years of service?
For 10 years cut off
So
date, I
yeah, yeah.
gone.
So that is gone.
Yes,
Number 2 part is whether you are entitled to payment of the minimum scale of pay.
my lord.
Now, what is the stand of the respondents? They say that you cannot work. Is it? They don't want your they don't want your
That
services.
the observation payment of record your lordship mechanism, page
Yes.
67. The number of days which have been mentioned,
Yes,
lordship, it's not correct, my lord, according to us, because we have,
those are different issues.
my lord.
That's a different issue.
My lord. And
The-
your lordship, our one more like contention is that similarly situated persons case have been considered, and those who have not considered, completed even 5 years, their cases will although are under consideration. So your lordship, at this stage, lordship, may I pray only notice be issued, my lord. And your lordship, we are pretty like Sahaya only, my lord. Only financial strength we need, my lord.
No, but
Just
then,
notice, my lord.
this is based on the Supreme Court judgment.
Uma Devi and all will not be follows. We are, lordship, this honorable court passed order in our favor, lordship at page 55, my lord, to 60. So we are praying for that consideration, because will not be, other aspect will not fulfill, your lordship. Because we have not completed 10 years, and that Uma Devi's cut off para 53 will not fulfill that. Only one for to run our family, my lord. Just a-
Maybe, but then that does not mean you see, the thing is, you are not the only person in this predicament. Now,
We are-
unless the state has the money to pay you, then what to do? How can you say, how can you ask a beggar to cough out money? From where will he cough out money?
Lordship, but one more factor, when they have considered the cases of other similarly situated persons who are working as we are working, and your lordship, number of days where those persons working less than us, then equal pay for equal work, your lordship, and Article 14, my lord. At this stage, lordship, kindly issue notice. The petty persons come up before this honorable court, only notice.
So you
my lord.
want payment of
One-time consideration, because earlier order is
what do you want basically? You want that
pay scale.
pay scale,
Yes,
minimum pay scale.
yes.
Right, third Ms. B. Boyan, learner counsel for the petitioners who submit that the speaking order dated 10/8/2023, bracket page 67. Should be set aside. And the petitioner should be given the minimum scale of pay. Issue notice, returnable in 4 weeks. Who accepts notice?
APDCL.
Mr.
Yes, my lord, in this matter, my lord may see the previous order which has been passed. There was only a request to consider, my lord. And we have accordingly passed an office order by following the judgment of the Uma Devi. And with regard to that, we have also said that we cannot do it. My lord,
45
there's
of-
nothing lying in this writ petition. In fact, my lord, the previous occasion, this writ petition was almost able to dismiss. They were almost able to dismiss. They tried to pray it. My lord, it's a request. My lord, it's not a.
Where is that order? Page?
There's no such order.
My lord, there is.
No, previous order of this one hasn't put.
Yes, yes.
You was talking about the matter when it came up last week.
Anyway,
In view of the, my lord, page 60, my lord.
yeah. Yeah,
In view of the without expressing expressing any opinion on the merit of the claim made in the writ petition, this petition is disposed of with the direction upon the respondent to consider the case in the light of the observation made in paragraph below the judgment and order dated as correct. Fail listing the above petition survey proper along with the support before respondent number 3.
anyway, let it not be dismissed on the first day.
My lord.
Mr. S.P. Sharma, learned accepts notice on behalf of the APDCL. List the matter of the point.
Issue notice.
Huh?
Lordship is issuing notice.
Yes, so issue notice.
Lordship may have for protection of
No,
our
no, no.
services. No.
Yes,
Our Mohinder sir is on lakes. He is in court number 2.
okay, after some time.
Next problem.
Yes,
May please, Your Lordship. My lord, the petitioner is put under suspension, my lord, because of a criminal case pending against him, my lord. But after within 3 months of his suspension, my lord, there was no search. So therefore, my lord,
but what about Rafid Ali?
yeah, I think
Lordship, here the petitioner has been released on bail, and he informed on 15/5/2023.
And
so
so-called notice.
so has been issued on
7/7.
7/7.
And suspension was
Within
on 6/3.
within a period of 90 days.
My lord, suspension on 6/3. The period should have been by 6/6.
I would have agreed with you. Only thing is that now judgment has been passed
I have got to it.
by this court.
And
So there are either two options.
Yes.
Either I agree with it, or if I disagree, I send it to the division bench.
Yes.
And I find that the judgment quite reasonable.
my lord, I will go through that.
Right. Heard, Mister?
My lord, may I just, my lord, in the prayer due to some that copy-paste, my lord, that it should have been DEO. In its place, it becomes deputy school. My lord, I'll just correct it by hand.
There is no correction allowed because the CIS doesn't allow that type of correction. It's not like before that you can correct it by hand.
My lord,
So
then I will-
there is I think notification issued by the High Court also that for any amendment,
Yeah,
I think that application should be made and a fresh petition should be submitted. Because that has to be again uploaded in the CIS system. And by hand, if you do, that is not accepted.
My lord, can I do it in the recorded experiment?
I'm dismissing your petition. There's no point. Because that ground that you're taking.
Yes.
Prior to Rafid Ali,
My lord,
this court would have allowed it.
I-
But
I may be allowed 1 week time. I will go through it. My lord.
no, I've gone through it.
But,
This the order is going to be passed by me, not by you. Heard, Mister? What is
yes,
it?
right.
J.H. Hazarika. T.H. Hazarika.
Yes.
Learned counsel for the petitioner who submits that the petitioner was suspended, was placed under suspension on 3/3/2023.
6/3, my lord.
6/3/2023. And he had been arrested on 3/3/23 in correction with ACBPS case number 9 of 2023 under section 7(a) of the Prevention of Corruption Act of 1988. The petitioner was released on bail on 3/5/23. And show cause notice was issued to the petitioner on 7/7/2023. The petitioner's counsel submit that in terms of the judgment of the uh, Supreme Court in Ajay Kumar Chaudhary versus Union of India, 2015, 7/6, 291, and the judgment of the division bench of this court in Rakibuddin Ahmed versus State of Assam and others, reported in 2022 GLR 621, the review for extension of the suspension order made on 6/3/2023, not having been undertaken within 90 days from the date of the suspension order, the suspension order cannot survive and has to be set aside. That is your case.
Yes.
Okay. Next part. The Mr. What is the name?
P N Sharma,
P.N. Sharma, learned counsel for the
School Education Department, Elementary Education Department.
Elementary Education Department. On the other hand, submit that in terms of the judgment of this court in Rafed Ali versus State of Assam and others, WPC number
The Division of
455 of 2023, which has dealt with the effect of the judgment of the apex court and the division bench of this court, that is Ajay Kumar Chaudhary Supra and Rafiq Kuddin Ahmed Supra, coupled with Rule 6(2) of the disciplinary and appeal rules
1964.
Huh?
1960.
1964, the government servant would have to be considered to be under suspension during the entire period he is in custody. As such, the time limit given for review of the suspension order for extension of the same pursuant to the judgment of the apex court in Ajay Kumar Chaudhary and the division bench of this court in Rakibuddin Ahmed would only be applicable from the date the government servant is released on bail and the same is intimated to the authorities. Next part. In the present case, the authorities have apparently been informed of the release of the government servant from on bail on
3/5/2023.
3/5/2023.
No, 15/5, Lord.
15/5/2023. Full stop. Even otherwise, the government servant / petitioner having been released on bail on 3/5/23 and the show cause notice initiating the departmental proceeding having been made within 90 days from the date of his release on bail, the same cannot be said to be. There is no ground for the petitioner to ask for suspension of his sentence in terms of the judgment of the apex court in Ajay Kumar Chaudhary Supra and the division bench of the case and the decision of the division bench of this court in the case of Rakib within Ahmed. Consequently, the petition fails and is dismissed.
Obliged.
May I please, your lordship. My lord, the petitioner before your lordship was initially appointed as a my lord, work charge, my lord.
What charge?
Work charge, my lord. Long back, my lord,
Long back when?
1987, my lord.
Work charge what?
He was appointed as a my lord, work charge in the PhD department, my lord, against my lord Ujan Kupa water supply scheme, my lord. And
Huh? As what?
work charge, my lord.
Work charge what? Work charge
Khalasi.
Khalasi,
Khalasi,
work
Khalasi.
charge electric, huh?
Yes, sir. Khalasi,
Work charge Khalasi.
Khalasi. At
Yes.
my lord Ujan Kupa water supply scheme, my Hailakandi.
Under the water resource department.
Water PhD only. PhD only. Then, my lord, he was appointed thereafter, promoted, my lord. It is 1992, page 15, my lord, pump operator, my lord.
Promoted as pump operator.
Yes, my lord. Assistant pump operator, my lord.
Then
Then, my lord, as usual, my lord, he was given, my lord, GPF account, my lord, page, my lord, 16. But, my lord, here, my lord, one thing happened, my lord. He got, my lord, as usual, my lord, as like as other regular employee, as a grade 4 employee, my lord, everything he got, my lord. Lastly, my lord, he received, my lord, almost 70,000 salary also, my lord. But formal, my lord, he did not receive any regularization order, my lord. This is the problem, my lord. Then, my lord, page 17, my lord, this is
so
my
he
lord,
retired.
retired, my lord.
When?
My lord, this is 1/8/2022, my lord. Notice given and with
No, 1/8/22 he retired.
no, my lord, 31/7/2022, my lord.
31/7.
Yes, my lord. This is the notice of retirement.
So
page,
you are claiming family pension.
regular pension, my lord.
Yes, I mean regular pension.
Regular
Yes.
pension.
Yes, madam.
Lordship, may fix a short date. I'll have to get the instructions.
Well, other matters are, my lord.
One
pending, my lord.
aspect is that he has not been regularized. So regarding that, I have to take instructions.
No, okay, assuming he's not regularized, okay. As per law, a person has to be regularized.
Lordship.
Unless he's regularized, he cannot get. But then can you see, should we allow someone to be, his service to be utilized for around 30 years and you suddenly throw him away,
36, my lord.
whatever. So that is another aspect of the matter that has to be considered.
Lordship.
I can understand you use a person for 10, 20, maybe 15 years, used to some work, and then when there's no more work, you let him go. But then when you use a person for his entire life, and I don't know whether it will be fair. As per the law, yes, he's not entitled. But I think there are provisions under the pension rule. I think 31.
Lordship, yes.
There's some provisos, I think, that where the government can pass some order. You look, that's- okay, right.
Well, similar matter, my lord, page 23, my lord. Along with that,
Page 23.
those matters, my lord, his colleagues, my lord, filed, my lord. Still pending, my lord. This may be, my lord, listed along with those matters. Page 23, my lord.
Okay, right. Mr.
AM Bolbia.
A.M. Borbia, learned counsel for the petitioner submits that the petitioner was appointed as a work charge Khalasi in 1987 under the PHE department. He was thereafter promoted as assistant pump operator on
My lord, on my lord, 21/1/1992, my lord.
21/1/1992. He was given his GPF account on
My lord, the date is not given, my lord, but
GPF account,
Confirm, my lord.
page 16. Pustak. The petitioner was thereafter made to retire from service on attaining the age of 60 years on 31/7/2022. Pustak. The petitioner's counsel submits that the petitioner should be given pension in terms of the Assam Service Pension Rules 1969, even though no regularization of his service had been made by the state respondents. First off, he submits that similar orders have been, he submits that similar cases are pending in this court, one of them being WPC number 5345/2021.
6315/2027.
That is the first case.
Yes, my lord.
6315/2021.
6315/2022.
Issue notice. Issue notice returnable in 4 weeks. Miss M. Kalita, accept notice on behalf of
Respondents 1, 3, and 5, Your Lordship.
1, 3, and 5. While Mr. A. Chali accept notice on behalf of point number 2 and 6. Accountant General, Miss Jedas, accept notice on behalf of point number 4. List the matter after 4 weeks along with WP. No, tag this matter along with the census.
My lord.
I would like
Keep your point.
Again, Rafid Ali.
Huh?
Rafid Ali.
Most probably must have heard. So out here, where he was suspended.
Arrested and he intimated on 11th of September, which is a page number 20. And still there is time till 11th of December.
Oh, that's right. No name has been
No
shown.
name, no name.
Mr. B. Sarkar P. Bashford. Right. No one appears for the petitioner. The cause this indicates that no name of the petitioner's counsel has been recorded. The petition the petitioner has prayed for setting aside the suspension order on the ground that no review of the same no review for extension of the same has been done within 90 days in terms of the judgment of the Supreme Court and the division bench of this court in Ajay Kumar Chaudhary versus Union of India 2015 76291 and Rakibuddin Ahmed versus State of Assam 2022 GLR. Next. Mr. D. Bora, Learned Counsel for the
Respond numbers,
respond numbers
3 and 4.
3 and 4. And Mr. S. Data for respond number 1 and 2. Submits that in terms of the judgment of this court in Rafid Ali versus State of Assam and others, WPC number
455.
2455. So. You just take down what I had mentioned there. Huh? Next para. In this case, the petitioner was suspended on, was placed under suspension on
7/7/2023.
7/7/23 due to his arrest on 7/7/23 in Patachar Kuchi PS case number 293/2023 bracket GR number 333/23 under section 379/411 IPC. Pusta. The petitioner was released on bail when? Yes, petitioner was released on bail when?
He was released on he approached the authorities on 11/9/2023. filed a
The-
representation.
The petitioner approached the authorities, informed the authorities on
On 11/9/2023.
11/9/23 that he had been released on bail. And prayed for setting aside the suspension order, correct?
Yes, sir.
Yes, sir. The show cause notice, is it?
No, so cause notice has not been issued.
Acha, the memo has nothing has been.
Not
Full stop. Full stop. No show cause notice / memo of charge has been issued to the petitioner till date. Full stop. As no one appears for the petitioner, in view of the fact that, in view of the reasons stated above, which appears to be due to the reasons stated above, comma, list the matter on Monday. I'm just doing this so that I don't have to read it again.
Yes, sir. Please, your lordship. This matter, Mr. B. Pata was supposed to appear from EC link, my lord, but there is some connectivity issue now.
Acha.
Otherwise, my lord, I am praying for a notice. in this.
Yes, we'll issue notice. We are praying for MACP, yes,
Lordship.
and I think the salary,
And the salary for the month of August, lordship,
August,
2023.
only for August.
August, lordship, from August, I have not. been
You know, we
received
pay.
salary.
Yes, you pay the salary, what is wrong? Yes, Mr.
B. Hazari,
B. Hazarika,
lordship.
your name is not here. Appearing on behalf of Mr. B. Pathak, learned counsel for the petitioner submits that the petitioner has not been given the benefit of the MACP scheme, and neither has he been given his salary from August 2023. Full stop. Miss
D Musahari.
D. Mushahari, the learned counsel for
Respondent number 1, 2, and 3.
1, 2, and 3.
Lordship.
Will issue notice?
Lord.
Issue notice returnable in 4 weeks. Ms. D. Mushahari accept notice on their response number 1, 2, and 3.
Three.
Petitioner will take steps for service of notice upon the respondents number 4 and 5 by registered post with AD within
3 days, lordship.
3 days. List the matter at the poll.
Public.
Obliged.
Matter relates to field officer. Madam, you have
Same order.
submitted this to same order.
Same
Yes,
order.
sir.
Okay, right. Same order.
Only one, my lord, 1 year, it is for 3 years. Appointment is given for 3 years in the present case.
Okay, in the present case. So it will be out
Only,
here.
only that much.
So you just say, as per the order dated 15/11/23, passed in 6/557 of 2023, same thing, huh? Except out here,
Line number
this
3,
will be 3 years.
everything is.
In the para 1, third line. Okay, I've put this here.
Deep, public.
Acha, wait, the respondent's council's name might be different. Huh?
Yes, sir.
Will be different out here. Out here will be,
I'm for 2, 2,
just
3,
a
and
minute.
4.
Mr.
I am for 1.
2, 3, and 4, Mr. S. Datta. S. Datta. And then Mr. Ardhar is already here.
For 1, my lord, and
Here for your Mr. Ardhar for 1,
1, my lord.
and for respond number 5,
5, my lord, record the name of Chalia.
A. Chaliha.
Yes, Chalia. Chalia. Publish both. May I choose, Lord? My lord, here, my lord, the impugned, my lord, notice, lordship will find at page 29.
Page 29.
29.
Yes.
Yes. Now, this has been, my lord, issued to the petitioner, my lord, without punishing the, my lord, complaint and findings of the inquiry committee and the
What findings are the inquiry?
Lordship.
made?
now preliminary
was-
committee.
There was withdrawn the
Preliminary
case.
inquiry, you're not required to have. Who says that? Preliminary inquiry, you're not supposed to get.
Now, yes, we are entitled to get under the
Okay.
act, madam.
Preliminary inquiry report.
Yes.
On 10/11, Lordship, they withdrawn the case, Lordship.
That is regarding
WPC number
suspension.
620, suspension.
That is
Lordship.
regarding
Yes,
suspension.
regarding suspension.
Regarding suspension, my lord, he has made appeal before the appellate authority. This is regarding suspension, my lord. This is regarding suspension.
Yes,
Yes.
show me that you're supposed to get the preliminary,
Yes. My lord.
thing.
Section 11, my lord, provided. Now, unless, my lord, we are given to the, my lord, complaint, at least,
No, complaint,
How-
okay, complaint,
yes.
I understand,
yes,
but the preliminary report.
Yes.
Whether that is a requirement, I doubt.
11, my lord, are provided for sure, my lord.
I said this is under the sexual habits.
Right.
That is physics. No, this is with regard to a inquiry.
Yes.
So this is with regard to an inquiry, that is before submitting a complaint to the police. It is before the police case that this inquiry has to be given to you.
Provided, my lord, for, I have marked, my lord.
Copy of the finding. No.
Now, unless I, my lord, provided the, my lord, complaint, my lord.
That
How-
complaint you have to give, you have to
Yes.
be given,
How
no
will,
doubt
my lord,
about it.
reply?
Complaint has to be given to
Yes.
you, yeah. That too you have been, not the findings.
Yes.
The preliminary inquiry findings, I doubt.
Now, no
That
complaint.
is an internal matter.
Yes, that is that.
That does not have any, it cannot have any, cannot be the basis for taking any action, the preliminary inquiry, only for ensuring whether a formal inquiry needs to be taken. in.
My lord.
That's all. Complaint, with regard to complaints, basically.
Yes.
He says that the show cause notice was issued to him, but the complaint was not given to him. So how will he reply to that?
So he made
Huh?
made a prayer for apology, Lordship, in para 20, Lordship, annexer 5, Lordship. He made a prayer for apology, Lordship.
Yes, that is
Lordship, he has ever that allegations are true, Lordship.
Page para?
Para 20, Lordship.
Para 20.
20,
Of the
page
effect-
20, annexer 5, Lordship, annexer 5, page 20.
Page 20. You said pay.
No, no, my mistake. Page 20, annexure 5. Immediately,
Oh.
I would say.
You sent a message to her.
That is the, it is true.
But by mistake,
Yeah, that was mistake.
your finger slipped. There was oil in the phone, I think.
For that, my lord,
Huh?
he made apology, my lord. This is true, lord.
WhatsApp message unfortunately sent to the
Yes,
wrong
yes.
woman.
Yes, my lord. That is the.
Was meant for your wife. All of us believe you. What is the complaint? Anyway, the complaint is that
Complaint is not funny. Lordship kindly see, my lord, page 23.
you give him the complaint. What is there? You give a copy. End of the matter. Tomorrow you bring it. We'll close day after tomorrow or whatever. I mean, tomorrow is the working day. We'll bring it tomorrow. We give it to him and finish. You sent some dirty picture to this
No,
lady.
no, my lord, actually on that night, my lord, he had a quarrel with his wife.
Ah.
So the my lord, wife, my lord, locked him in a different room.
Ah.
So under my lord, mental pressure, he
So you wanted to send a dirty picture to your wife?
no, my lord, he
Not-
sent
Huh?
he should my lord, send some message to his wife to unlock the door. But because of my lord,
To unlock the door.
yes, unlock the door. But because of some mistake, my
What
lord,
was that? What was that dirty picture you sent?
my lord, it was told me that the message portion is that I love you, darling. That was the message. I have been told.
So that will open the door.
Yes.
How many times do you send messages like that to your wife? She must have received it for the first time in her life. Huh? Anyway, right. Heard Mr. M.U. Mandal, learned counsel for the petitioner who submits that the copy of the complaint on the basis of which the show cause notice dated 31/10/2023 had been issued to him has not been furnished along with the show cause notice. Full stop. Mr.
A Chakravarti.
A. Chakrabarti, learned counsel for the
Respondent number 1 to 5.
1 to 5 submit that he will produce a copy of the complaint on the next date. List the matter on
12 December.
12 December.
But till then, no courtesy action. Otherwise, there is a strict,
It is not
strict
fair.
time limit.
You give a show. Why you 12 December? You give it next week.
Not sir.
When?
Then not sir. 8 lot sir.
Next week.
Say next week.
Today is 17. You bring out 22nd.
22nd.
On 22nd. Or make it 21st.
22nd.
22nd.
But till then, no courtesy action. Otherwise, Lordship kindly see.
The prayer for interim order will be considered on the next day.
Till then, my lord, because the time schedule is very tight, my lord.
How many days? 10 days.
10 days time.
10 days.
Now,
And this order was issued.
31.
Huh?
Petition, my lord, 31. If I fail to, my lord, reply within, my lord, 10 days, then they will.
31/10, already 10 days, already gone. Today is what date?
17.
Then,
So, my lord, till then, my lord.
and you came now. No, you have come late also.
Obliged. Obliged, lord.
Please, your lordship. My lord, here in this case, my lord, by last order dated 17/10/2023, government council is obtain instruction. My lord, here, my lord, the petitioner was selected for a regular vacancy, but he appointed on stipendiary vacancy. Thereafter, he was
recommended for junior basic training. He successfully completed his junior basic training.
Lordship,
Then, my lord,
the petitioner, the initial appointment of the petitioner itself was illegal, lordship. In terms of the cabinet decision in 2023, a screening committee was formed. And pursuant to thereto, the petitioner was accommodated as teacher, lordship. But he did not join, lordship. We are going to file our affidavit. He has been accommodated as teacher,
Will you file the affidavit?
lordship.
That's right. Heard Mr. A.R. Singhdal, learned counsel for the petitioner, issue notice, returnable in 4 weeks. Mr.
P. N. Sharma, lordship.
P. N. Sharma, appearing for the respondents number 1 to 4,
1 to 4, lordship.
submits that affidavit of position will be filed. When?
3 weeks, lordship.
Have you received instructions?
So I have received instruction.
Submits that instructions have been received by him,
Okay.
and he will be filing affidavit of position within 3 weeks.
Lordship.
This is the matter. Give a date.
Problem.
Leave lovely.
Item number 6.
Number 6?
My lord. It was passed over for the time being, I apologize, I was on the legs.
Yes, yes.
My lord. Now, here, my lord, the challenges to the initiation of a departmental proceeding. Now, if lordship would kindly.
Challenge your departmental proceeding.
My lord, yes. The show cause notice itself.
Basically, my lord, here.
No,
Criteria.
lordship will allow me to place. This will lead to a chaos.
Okay, just tell me.
Lordship, the petitioner who had joined her services in the year 1987 had been issued a show cause notice, which lordship will find at page 32 on 3rd of August 2002.
Yes,
Can I read the show cause notice from the top?
yes.
Subject show cause notice. You are hereby required to show cause under Rule 9 of the Assam Services and Discipline Appeal Rules, read with Article 311 of the Constitution of India. Why any of the penalties prescribed in Rule 7 of the aforesaid rule should not be inflicted on you on the following charges. Now, lordship will come to the last paragraph. Under the above facts, it is clear that you have committed a punishable offense by submitting fake documents and got appointment by cheating the board authority. Now, my lord, my first submission is Honorable Supreme Court and different Honorable High Court have held a show cause notice, which already determines which is a show cause notice, why a punishment should not be imposed, coupled with the fact that there is a clear finding that I am punishable, is a show cause notice which is not valid. This is a show cause notice which does not for once keep an open mind of the disciplinary authority. Now, if lordship would allow me, if I may just place a few paragraphs of the Supreme Court which shows how a show cause notice to start a disciplinary proceeding is to be issued. May I place that, ma'am? How these two sentences would debar the very show cause notice. They may proceed with a show cause notice if they have acted with an open mind.
Okay, so that's the, so, okay, so
Things have also proceeded further.
where is the citation?
My lord, yes.
It is the change of word.
No, madam, the change of.
You should,
words
you,
to be
instead of saying it is clear that you have committed, you could have said that it appears that you have committed.
My lord, yes.
Then that would have solved the entire thing.
This is 2010.
Submit a fresh one, that's all.
Further, we'll read the
Now-
allegation.
Thereafter, madam, what has happened is, I had given a reply, a written statement to the show cause notice. The inquiry officer called me to the office, asked my version, and he submitted an inquiry form. I approached this honorable court, saying that this inquiry is entirely biased because even that part has not been, no witnesses were examined. Inquiry officer had appointed the presenting officer, and I was not given any opportunity. This honorable court set aside all the proceedings immediately after the show cause notice. That it will again start from the point of show cause. The show cause notice will remain, the rest will again start. What the department now does is.
No, so the show cause notice.
Madam,
So the court, what did the court say?
the court lordship will find at page 54. I'll refer to page 53, madam. The facts in the page 53, madam. The facts in the instant case, however, reveal that though the allegations against the petitioner may be termed as serious, there was no procedure adopted, recognized by law to establish the allegation that there were no witnesses. The statement of the officer of the SEBA, though may be a relevant material, the same has to be proved in the proceedings by giving the delinquent an opportunity, which has not been done. Thereafter, it says, the Honorable Supreme Court, in the case of so-and-so, has made it clear that though a pre-recorded statement may be used in a departmental proceeding, the person making a statement would have to be produced in the proceeding so that the delinquent gets an adequate opportunity to cross-examine him on the basis of such statement. Even that procedure has not been adopted and the inquiry report is accordingly prepared. This court is of the opinion that the procedure.
Okay, we'll
adopted
issue
after-
notice. I think we cannot decide straight away.
But in the proceedings,
Huh?
what lordship will also consider, Honorable Supreme Court has held that till my subsistence allowance is paid, I cannot be asked to participate in an inquiry.
What?
Till my
Unless-
subsistence allowance is paid, any proceeding done in the inquiry prior to payment of the subsistence allowance is non-extant law.
I don't know, let us see. So the proceedings are continuing.
So what had happened is on the last. day
Anyway,
the
this show cause notice. And this, there's no challenge to this.
No,
So
show
this
cause
is,
notice. There is, madam.
no.
In the
But
criminal,
no,
there is.
But then this court, in the last order has said that the procedure adopted after the issuance of the show cause notice is not
Yes.
recognized by.
So the proceed.
So it implies that the show cause notice, there's nothing wrong with the challenge.
Lordship will only appreciate. The show cause notice, after that, all the procedure has gone. So therefore, my stand is now from the date of receipt of the show cause notice, it has to start again. Therefore, when they remain with the same. show cause
No,
notice,
it
that
is
is what I'm saying.
after issuance.
Exactly, madam. It is after the issuance of the show cause notice, I can come back with a challenge to say that the show cause notice
Then
is
you
wrong.
go and review against this order. You say that this aspect has not been clarified.
No, so when I had approached this honorable court, it was at a stage when they had given me an inquiry report with nothing. I had no opportunity to participate. Lordship will kindly have that paragraph.
No. Anyway, you give me that, you give me that citation regarding subsistence allowance.
Subsistence allowance is always there, my lord. That is one part. And second, my lord, appointment of the same inquiry officer to continue with the inquiry
Anyway, the
is
fact,
also there, my lord.
anyway, we'll see.
But my lord, subsistence allowance, my lord. From the last date.
So the proceeding has started again.
Started,
Evidence
my lord.
has been taken.
My lord,
Evidence is being taken.
evidence has been taken.
What has
She
been
was
done is,
called
my lord,
for-
on the last day when the matter was listed before this court, the disciplinary proceeding was also
State
on the
in-
same day. It was stayed on the same day. However, they recorded the evidence of the official of the SEBA. Now I have been given a notice yesterday to appear again tomorrow. The SEBA official has not been called in, other witnesses have been called in. When the matter was before this honorable court, my lord, I even lose the opportunity for cross-examination of the SEBA director. The official of the SEBA, even that is going to take. Although the matter was listed on a day when the disciplinary.
No, just show me the. I will-
The Supreme was state, my lord, because subsistence element was not paid and my learned friend.
No, that is not the only ground that I am taking up.
That is the ground, my lord, from the order it appears, my lord. And the subsistence allowance, the order has been passed, my lord, on 14th, that 50% will be given to the incumbent, my lord. And yesterday, the amount has been deposited to the bank today.
Okay, so substance allowance have been given to them.
Today, it will be transferred to her account.
Yes, Chairman, my lord. Regarding the substance allowance, anything done prior to that. So therefore, my lord, even the witness which was taken on the day, which is prior to the payment of the substance allowance,
What about area salary?
not paid.
Area city is not yet paid, my lord.
You pay that?
Yes, sir. We will do it. But that does not affect the departmental.
It has to, that is what the Supreme Court says. Connection to the arrears. Connection to the-
1973, one SCC 656 is before your lordship.
Huh?
1973, one SCC 656 is before your lordship. Is that the judgment before your lordship?
The lordship would come to
Yes, sir.
paragraph 5.
Yes, my learned friend just now.
This is another judgment.
Yes, which one are you referring to?
Paragraph 1976, 1973.
Yes,
Lordship will find at paragraph 5.
5 years.
With respect, we find it difficult to share the view taken by the High Court. At paragraph 5, the repetition expressly alleges that on December 5th, 1964, the appellant sent a letter to the inquiry officer informing him that unless he was paid subsistence allowance, he would not be able to face the inquiry proceedings. The letter was filed along with the petition. This annexure, it is annexure H. The letter states that unless and until I am paid the subsistence allowance, I categorically refuse to face any proceeding as I have no capacity to do so because of the accused shortage of funds. This is obviously specific pleading on the point of non-payment of subsistence allowance. He was short of funds and he could not enter the inquiry. It is true his affidavit does not give any particular about his sources of income and the estimate of the expenses to be incurred in the inquiry, but it would be prima facie suggest that he had no other source of income except his pay. If he had no other sources of income, he could not invent them for the purpose of mentioning them in the affidavit. More significantly, the government affidavit does not allege that he had any source of income except pay. The fact that he had been drawing a monthly salary of rupees so-and-so till October 64 would not necessarily show that he had sufficient money to enable him to go to Jagdalpur to attend the inquiry in February 1965. He was suspended on 1964, October 30. Therefore, he did not get the, and thereafter, he did not get the subsistence allowance till March. Having regard to the prevailing high prices, it is not possible to draw any adverse inference against him from mere circumstances that he had been receiving a monthly pay of rupees so-and-so. The fact that he filed a writ petition immediately on the passing of the order of dismissal and therefore thereafter came in appeal to this court would not establish he had enough resources to enable him to attend the inquiry. It seems to us that on the whole, the High Court has gone by conjectures and surmises. There is nothing on record to show that he has any other source of income except pay. As he did not receive subsistence allowance till so-and-so, he could not, in our opinion, attend the inquiry. The first payment of the subsistence allowance was made to him on March 20, 1965, after a part of the evidence had already been recorded on February 9, 10, and 11. The inquiry proceedings during those days are initiated accordingly. The report of the inquiry officer based on that evidence is infected with the same defect. Accordingly, the order of the government dismissing him from service cannot stand. It was passed in violation of provisions of Article 311(2). Therefore,
Okay, in
the
this
other
case,
This judgment Malad, can be differentiated.
in this case, the person had not attended the DP
yes,
because he did not have the money to attend the
that is what I
DP.
have stated in my.
But in your
application.
case,
I have stated the application, madam.
what?
I have given them the application
That
that my subsistence allowance is not being paid. I do not have the funds. I am
to go for the inquiry.
Yes.
that is exactly what has happened here. Also.
No, my lord, let me
Then
explain,
lordship
my
will
lord.
have the
Here
other
in the judgment, my lord, if I may be allowed to submit, my lord. In this judgment, the difference, place of difference, my lord, from the inquiry, where the place of inquiry and the place of residence was 500 kilometers.
Okay.
Here, not even 5 kilometers from Nunmati to Sanmari.
No, she can hire she can hire a
reputation.
reputed lawyer, but she cannot go by bus.
Two litigations, my
But
lord. This is
lordship
the
will
second
kindly
round of
see-
litigation.
Lordship will kindly see that is exactly what the Supreme
She
Court said.
cannot come from
Approaching the
Nunmati
High
to
Court.
Sanmari, my lord.
What
That
is
is
Supreme Court?
filing
What to do? What to do? She can hire a lawyer to come here,
Yeah.
but she can't go by bus.
My lord, she had approached the legal services authority. They wanted a time of 1 week to file the writ petition.
And you did it for free.
My lord,
And you did it for free.
my lord, the expenses have been paid. I will not. Expenses. Lordship will have the other. judgment.
Anyway, that is a different issue.
My lord.
So anyway, so you have paid the subsistence allowance.
yes.
So it has gone to her account.
Yes.
Have you got the
My lord, my
money?
instructions at 6 o'clock. Yesterday at 6 o'clock, they had passed an order that I would be entitled to the salary allowance. I have not. I tried contacting my.
Not been given.
She has not
It was
informed that she has
14th.
received the money.
It was passed on 14th. Order was.
The order
No, you see,
received-
when was it transferred to her account? Just like-
Yesterday, no, my lord, that NEFT process is being initiated. The amount has been given to the bank authorities. Now it will be transferred. Today
NEFT
by
does not
evening.
work like
Today by evening, that
NEFT
will be
works
transferred.
immediately.
Amount will be transferred.
And what about the area salary? You give the area salary also.
That will be provided. Now, my lord, the proceeding has been stayed because subsistence allowance was not being paid to the incumbent. Now that is paid, my lord. So, my lord, let the authority proceed with the proceeding. Let her appear. Let her, if she wants to cross-examine the board authorities,
If lordship
Because
has
the
other-
allegations, my lord, allegation is that she
No,
had
no,
provided.
what about the aspect of the show cause notice? Show me that. Then
the judgment matter is. 2010 13 SCC 427 para 31. Page 430 427.
ah,
2010 13 SCC.
was this issue taken up in the last writ petition?
The question of the show cause notice, madam. We had alleged that there was bias on the part of the disciplinary proceeding in initially.
Same. So you took up the issue,
Madam, yes.
and what did
But
the?
At the stage of when the matter was being argued, it was only the inquiry report which was taken up by the learned civil judge, madam. And therefore, madam, we had to argue only on the inquiry report. When he found that the inquiry
No,
report
but
was
then,
complete-
but then can you re-agitate an issue which was already there and which
Madam,
you
it
might
was-
not,
it was-
and it implies that you might not have pressed it.
Lordship will kindly also appreciate that since the learned judge, single judge had sent it back to the stage of show cause after the show cause notice. It was at that stage, to my understanding, my lord, that I could come back to challenge because the rest of the part is
I
over.
doubt.
It is only a stage where now it starts from the show cause notice. I have a show cause notice in hand, the rest of it has been set aside. Lordship will find that. Kindly
Why
sentence
don't,
again, my
you
lord.
see, otherwise, now what will happen is, in writ petitions, there are maybe 10 points taken up and maybe 3 points are usually pressed. Now supposing I decide a case with regard to the 3 points, you'll file another case on the same point which has not been decided by me in the earlier case, saying that he did not decide this. Now,
That is not the.
that is
the
what
case.
they are implying. They are
No,
saying that
what
it
I'm
was a
trying to-
point there, but at the time of hearing, the court took up only the issue of inquiry report.
I'm not saying it is not. I said the court noticed that the inquiry report is totally wrong. So it was sent back to a stage of when I received the show cause notice, so that now it can be correctly done.
I don't.
Lordship will kindly have
If I
page
may take your lordship to
page
page
436.
Just a minute.
Page 436, madam.
436, yes.
Para 31.
31, yes.
It is of course true that the show cause notice cannot be read hypertechnically, and it is well settled that it is to be read reasonably. One thing is clear that while reading a show cause notice, the person who is subject to it must get an impression that he will get an effective opportunity to rebut the allegations contained in the show cause notice and prove his innocence. If on a reasonable reading of the show cause notice, a person of ordinary prudence gets the feeling that his reply to the show cause notice will be an empty ceremony, and he will merely knock his head against the impenetrable wall of a prejudged opinion, such a show cause notice does not commence a fair procedure, especially when it is issued in a judicial proceeding under a statutory regulation, which promises to give the person proceeded against a reasonable opportunity. Therefore, while issuing a show cause notice, the authorities must take care to manifestly keep an open mind, as they are to act fairly in adjudging the guilt of the person proceeded against, and especially when he was the power to take a punitive action against the person after giving him a show cause notice. The principle that justice should not be done, but it must eminently appear to be done, as well as is equally applicable to constitutional proceeding, if such proceeding has to inspire the confidence of the mind of those who are subject to it. Now, my lord, if I'm allowed, if we may take the judgment of honorable high courts which have dealt with this matter, my lord. reference and all. The Honorable High Court of Rajasthan, the Honorable High Court of Patna, even this Honorable Court, my lord, has specifically held that when a show cause notice determines the punishment which is to be given. This is the punishment I propose. So, and Lordship will see the show cause notice, it specifically says why the penalty should not be imposed. At page 32, it starts with why the penalty should not be imposed. And it ends with saying that it is a clear case. Under the facts, it is clear that you have committed a misconduct.
Where else says that why the penalty? Where else?
The first paragraph I remember, you are hereby required to show cause under Rule 9, read with Rule 311. Why any of the penalties prescribed?
Why any of the penalties? That's not right.
My lord, that is the sentence which has been held to be wrong, my lord, by Honorable High Courts, referring to Orfix. Referring to Orfix, my lord, the Honorable High Courts have held that if this is the language used in saying that why
Show me,
this
show
penalty-
me,
My lord, yes,
show me our High Court.
My lord, yes, there was a judgment by that is 2017-3 GLJ 714.
GLJ
GLJ, my lord, Guwahati Law
714.
714 is the judgment. I have taken printouts. Lordship will give you just 1 minute, my lord. I had copies of it. No, well, I've been literally just a bit. It should take me 5 minutes, my lord. I'll take a second print out, my lord. Take a minute. Go in the website. Hey, Tara, can you try? You can have this indication. Jingo can assign it. I made a mistake when I kept the printouts on my thing. It really didn't come with the pen.
Allegation by that. At the time of appointment, the HSLC certain technical.
No, I know. The facts are quite serious.
And page
The fact-
38, page
Only thing
38,
is that he's on the technical aspect.
Yes,
You see, one thing is,
page 38, my lord.
just a minute.
Yes.
One thing is that out here in the last para, I have said that it is clear that you have committed a mistake. So you have already predetermined.
Now-
So why don't you just make a change? It appears that, or it appears that you have committed, or
In the focus notice.
yes, it is alleged that you have committed, or something like that. Just a change of word. And the change of when this, you are liable, you are required to show cause and so.
Why the
Why
penalty
any of the penalties prescribed? No, this I don't think there's anything much wrong. Let us see.
This is the Rajasthan High Court. I have sent for the JLJ. Lordship will kindly have the Rajasthan High Court for a minute. It has also referred to Orfix, madam. Lordship may like to come to page, to the sixth paragraph, madam.
No, I don't find any wrong. Exactly.
Lordship will find it
Rajasthan High
says.
Court may say anything.
No, my lord, the Guwahati High Court, I'm just sending it for my lord. I left the copy at my table.
And page 38, my lord, that is proved, that has been proved, my lord, of late. It's the letter by which it has been said that the records of the petitioner does not exist in SEBA, that letter has been proved,
Have been proved.
have been proved.
My lord, if the proof is already there.
Huh?
If it is already proved, that itself shows that it's a big revenue.
No, they are proving it.
No, what had happened is this, my lord, if just in the time the books comes, my lord, if I just trace what had happened actually. In the year 1987, my lord, I was in class, I was around 18 years of age when my father died. So.
You see, your case is basically on technicality.
No,
With
that is
regard,
the-
with regard
since-
to,
no, since
with
you have found
regard
the
to
proof-
facts, this court cannot sit as a court of appeal on the merits.
No, I do not
That-
want this.
It's only on the procedure.
Our prayer is not that it should,
So
this
anyway,
court will decide.
so
Prayer is-
we'll list it again next week.
That can be done, my lord, only difficulty is the proceeding has been stayed till today.
You see, proceeding,
on
you
the
see,
ground that
only,
subs-
yes, that subsistence allowance, once I have proof, I'll list it next week.
Fine.
Once this court has proved that subsistence allowance has been paid. And you pay the arrear also.
Yes.
Once subsistence allowance has been
The
paid, the proceedings can continue.
thereafter. Let it be,
Please let him bring his judgment also in the meeting.
let it be on Monday, my lord, or.
Yes. That Mr.
PK Munir.
PK Munir, learned standing counsel, Assam Khadi and Village Industries Board submits that the substances allowance would be transferred to the petitioner's account by today. By today. Full stop. As this court would like a definite answer with regard to the same, list the matter again on next week, Tuesday.
Tuesday.
21, I am not here. Could it be on the 22nd or 23rd?
22nd.
My pleasure.
Obliges.
Interim order to continue till 22nd.
Obliges.
Maybe your lordship. Lordship, the matter may be possible for the time being.
Just put this. Yes,
The matter may be possible for the time being.
item
14, 1 4.
1-4.
Your council is 1 lakhs in other court.
Passed over
Possible for the time being,
for time being.
after some time.
Who is for the other side? State of Assam. Yes, who is there? Listen. Just put off the AC. After some time, next.
May I please your lordship? Senior is out of station.
Who is his senior?
Dr. Vivekananda Gogol, VN Gogol.
This is with regard to what?
Retirement benefits of the petitioner's husband who was missing from the
Since
85.
85. And you are coming now.
And we are fighting from 2017.
Only
Lordship,
after-
we didn't
if
get
we
the
get anything,
instruction
madam.
from the department.
Commissioner and Delhi Finance Minister of Finance also time and again return them, settle the matter, settle the matter.
Have you filed, did you submit any FIR?
Yes,
When?
of course, later on, not
When?
after the long gap, madam.
When?
No, I have not filed any, not the department has also filed.
You have not filed.
I have not filed, not the department filed.
Your husband.
I am the wife now.
Naturally, you were the wife then also. You could not have been the husband then and the wife
Yes,
now.
fine.
You would have remained the same, I think. So, your husband went missing in 85
Yes,
and you never filed FIR. And went missing when in 1985. So for 38 years, you are quite happy that he's gone missing.
I am not happy.
Now you are sad.
I am not happy, but I am
Now-
surviving. I'm struggling to survive, madam.
That-
I am in
now-
young
now-
age, madam, where husband is missing.
Now you don't want your husband, but you want the money.
If I can.
Naturally, but you don't want the husband.
It is
Because
only-
if your husband
there
comes,
is
then no money.
No, madam, there is no hope to return after long gap.
You have not even filed FIR, I don't know.
That is the ignorance of our people, madam, illiterate lady.
Government,
Illiterate-
government servant,
No,
government
husband-
servant's wife.
Government is the group D, my lord.
No one is so stupid. Mr. Kaur.
Now nowadays, madam, with the legal awareness also very big problem, madam. Nobody understands what is the importance of the affair, madam.
Anyway, right. Uh,
Lordship, we have to take instruction from the department.
I know, right. Heard Mr. S.C. Biswas, learned counsel for the petitioner, who submit that the petitioner's husband went missing on 5/12/1985. Correct?
Yes, yes.
Good stuff. The petitioner's husband was working as a group D, in a group D post under the respondent number 4. Good stuff. The petitioner's counsel submits that the petitioner is entitled to the family pension and retirement benefits of her missing husband. Gustav. He also submits that that neither the petitioner nor the department in which the petitioner's husband was working in has filed any FIR with the police till today. Then I do not know how you are going to, how is the question of death 108 being going to be applied. And, we issue notice of what?
Yes, sir.
Issue notice returnable in 4 weeks.
Oh, it is already they have appeared, madam.
Huh? They have appeared.
Long ago. It has been filed.
But notice has not been issued. It's still in the motion stage. Is that correct? Admission stage.
Admissions.
What's the admission? As no one, as adjournment prayer has been made. But why do you want to adjourn?
Lordship, senior is out of station. Also, we have to take the instruction from the department.
So this case was filed in 2017, madam. How many more years do you want for instructions? 20 years?
We have given them
When is your senior coming back?
on Monday.
Monday? So, right, as this matter has been hanging fire in this court for since 2017, list the matter on Wednesday.
Yes.
You see, you have to file FIR, and without that, how will you go forward? Very true. Huh? 19. 18 has been, I think, adjourned. For they received instructions and they wanted time to file their affidavit. So since they have received instructions, wait. Yes,
Matter relating to matter.
disparity of pay.
Hello.
Matter that's a
As per
existing
order,
law, existing matter,
Huh?
rules matter. 1990 there is a existing rule of staff nurse.
But then you are what? You are what nurse are you?
Staff nurse. Matter kindly have a look, matter page 33.
No, and can we dispose it off?
No, Lord.
Why?
As per order dated 4/10/23, Lordship, I have received these instructions.
There's a subsequent development, my lord,
Yes.
because the cases of all the nurses have been forwarded to the finance department of the health department for consideration, my lord. In the case of the petitioner, they do not BSc qualification.
BSc nursing diploma.
Yes, my lord, that since they did not possess that, so they're claiming there's some disparity in the payment, my lord. So regarding that, there was a call has been taken, a decision has been taken by the Health and Family Welfare Department, my lord, which I have been intimated today itself. So they are saying it's pending in the Finance Department, lordship. So lordship may allow me some time, I'll just find out what is the status of the proposal that has been.
Matter these matter instruction matter regarding matter new rules, matter new draft rules matter. I am claiming matter in the 1991 rules matter. There's the existing rules matter. In the existing rules, matter, kindly have a look at page 33 matter. The staff nurse matter. There's no discrepancy matter. And now matter respondent has matter saying that matter they are now preparing a draft rule matter, new rules matter. Even there is the existing rules matter. I'm claiming matter. In the last
Have you seen this letter?
no,
Huh?
I have seen that.
You've seen. What does it say?
What is the matter draft rules?
Where does it say? When did you see this letter?
No, no, no.
Just now. Where does it talk about draft rules? The draft has been sent. Okay.
Draft rules has been sent to the finance department.
Finance Department.
But last what
Where
happened?
is the draft rule? Let us see the draft rule.
It is not with us, Lordship.
How do we know that your draft rule is going to have any?
Their submission was made by a long back.
Lordship, it's Assam.
You know, last order, my lord, this
Assam nursing service rules, my lord. That is a draft, my lord, and they'll be covered because they are also nurses, my lord. That's like, from what I can understand.
No, let us see the draft. You bring the draft rules.
well, kindly look at the last order, my lord. This was reflected.
No, Lordship, it is not with us, Lordship.
I know it is not with
The
you.
instruction only.
In the
You
last,
see, the problem is that we want to see whether that draft rule has anything to do with them.
No, it is sent to the Finance Department.
Madam,
Lordship.
is it the only copy in the whole world that you have sent to them? Don't you have any other copy?
Then
Ah.
Lordship may take it up after some time. Mr. DP is conducting the case. We will come.
Yes,
come
please.
late.
Okay. Please call him.
Lordship.
Right. But can you see the order dated 11/10/2023, whether?
Yes, what is to be done?
Lordship, may kindly have a look the Honorable High Court order 1110. The last portion of recording the submission made by the Learned Standing Council WMD. The respondent are permitted to make a proposal for supplementary demand for payment of arrears to the finance department. And we have forwarded, my lord, to the finance department, and finance will get the instruction when they can.
If a copy is given, lordship, I'll find out the status, lordship. It's pending, that means that it's under consideration, my lordship. Approval will be given, my lordship.
In fact, they have filed one IA for implementing finance department. Notice yet to be issued to the finance. Notice yet to be issued to the finance department.
Yeah. Now you have been made, you have been made,
Yes,
right?
yes, party.
Right. Miss MD Bora, Learned Standing Council,
WMD department.
WMD
MD.
Department submits that the Joint Secretary to the Government of Assam, WMD Department, has written a letter to her dated 16/11/2023, informing her that CF advance proposal for payment of arrears salary to the petitioner has been submitted to the Finance Department by white proposal number CF-CAD-0002 for release of funds. Good stuff. Next paragraph. It is seen that the Finance Department has been made a party as respondent, a party respondent number 5 on 18/10/2023. Mr. A. Chaliha, appearing for the respondent number 5, shall obtain instructions with regard to proposal number CF-CAD-0002 dated 7/11/2023. No, 8/11 actually, signed on 8/11. 8/11/2023. Issued by the Commissioner Secretary, WMD Department, wherein a sum of wherein
5 lakhs.
5,04,687 has been requested for sanction. To be made. Leads the matter on. Mr. A. Chaliha shall obtain instructions with regard to
2 weeks I can find out.
leads the matter on. Give a date.
Well, that may be given.
My
5/12.
Obligation. My lord, may keep my instruction as a part of the record, my lord.
Okay. The letter dated so is made a part of the record and marked as an extra.
Okay. I'm deeply obliged, my lord.
Letter dated 16/11/2023. Huh?
Deeply obliged.
Yes.
Petitioner having Latmodo Revenue Circle under suspension lordship. And lordship, the petitioner received on retired already, he was already retired lordship.
Retired when?
30/11/2020 lordship.
30/11/2020.
2020 lordship. And lordship petitioner only received for provisional pension lordship. And
Receive provisional pension.
for provisional pension lordship. And lordship, the area salary and other benefits not received lordship.
So you are suspended.
Yes, lordship suspended, and lordship departmental procedure already with your lordship and
As departmental proceeding ended,
yes, lordship, and deputy commissioner, district commissioner order issued.
you are acquitted or
Yes, lordship.
acquitted?
Lordship. But lordship criminal case is pending also.
Oh, okay.
Only because of that, Lordship.
So is there any order from the governor under 21? What?
He is getting the provisional pension also.
Yes, Lordship, but
Mr. Council, there is a manner in which family pension or pension, whatever, can be withheld. Now that procedure has to be followed. Has it been followed?
That instruction I need to obtain.
last occasion, Lordship, instruction, last occasion, directly the instruction, Lordship, last occasion, Lordship. 16/10/2023, Lordship.
That's why, Lordship, I took the telephonic instruction, Lordship. But what Lordship has asked, Lordship, that I have to apprise you, Lordship.
This is because one thing, I think as per 21, I think, rule 21, the governor can withhold the pension if there is some criminal proceeding and DP. Yes,
Rule 21(4).
have you read it? Or you are relying upon what he's saying? Supposing I tell you that there is no sub rule 4, then what to do?
Actually, your lordship, if because DP was actually going on before his retirement, if suppose the DP had actually commenced after his retirement, then governor's consent should have been taken. That is what, as my understanding of 21 goes. Of course, I have to look into exactly that language. But since DP had actually commenced prior to his retirement, therefore governor's consent is not required here in this case. Now the criminal case is pending in this, as I've been told. So he has to actually ascertain whether that case is concluded or not, whether it is still going on.
Department of Control already approved.
Not DP to do, but now I know a criminal case to have done. It is not happening. What I think you want to write over
When was the criminal case started?
2020 lordship.
What is the stage of the criminal case?
Lordship, the criminal case is already pending, lordship.
Huh?
Pending, lordship.
What?
Pending, lordship.
Pending to, I know, what is the stage? Pending to pending is,
Yes, lordship.
pending can cover many stages. Whether it's in the stage of evidence, stage of consideration of charge, stage of argument, stage of 313, what is it?
Criminal case, lordship.
Right. Petitioner's grievance is that no regular pension has been given to him despite having retired on 30/11/2020. Petitioner has only been given provisional pension and subsistence allowance.
Only received lordship for pension, lordship.
Subsistence allowance not
And lordship
Not given.
not given.
Acha,
area salary and other benefit not given, lordship.
just given only subsistence allowance you cut. Mr. S.R. Barwa
Lordship.
submits that the criminal case initiated against the petitioner is still pending before the learned trial. Party shall inform this court as to the stage of the criminal case. pending before the learned counsel. This is the matter after 2 weeks, 3 weeks. Next.
Yeah, please, your lord. The matter relates to the pension of the petitioner who lost her son in a bomb blast in the office while this boy, her son, was working in the office, madam. And he died in the year 1986, madam.
86.
Yes.
And you have come when?
My lord, I have come from the through legal aid, my lord, because she doesn't know. She was begging, my lord, sometimes then she
After
came.
36 years, you come to this court.
We have moved, we have written several letters, my lord, they are not responding.
Yes, who is appearing? Forest Department.
Very pathetic death he met inside the bomb explosion office itself.
What to do?
Last occasion, they took time to file affidavit, madam. Several dates they took time.
Look, the problem is we cannot be in such a hurry now because you were not in a hurry for the last 36 years.
But I am now,
And suddenly,
she may die at any time because she
right?
is 80 plus.
That is the reality all of us are going to face.
But matter is pending since 21.
And cause of action arose in 85, 86. Yes.
Lordship, I am for the Forest Department. Lordship, instructions are very clear. Actually, the son was not appointed as against any permanent post.
Oh, you're not a regular government servant.
No, Lordship.
But my lord, after 10 years of the service, I died in the office. I have given my life for the country. And I will be denied pension.
Not only you, a lot of
Yes.
a lot of non-government servants also have died.
Yes. But they are getting pension, they are getting all benefits.
Non-government servants don't get pension.
They don't, may not, but their huge compensation they are getting.
No. You have to come as per law. If you're not a government servant, I mean, if you're not a regularized government servant, what was, show me his appointment order, give me some details, not, well, where is your appointment order? Let us see.
Yes, but my lord,
Casual worker,
casual worker, yes.
no case, Mr. Okay, right. Heard Mr. S.C. Biswas, learned counsel for the petitioner, and Mr.
I brought up
I. Bhattakur, learned counsel for the
Forest Department.
Forest Department. Pusta. The petitioner's case is that her son, who was working as a casual worker in the office of the divisional forest officer, Sonitpur, died in a bomb blast which occurred in the office on
15,686.
15/6/86. The petitioner, who is now an old lady of 80 years, was wholly dependent on her deceased son. As she is unable to support herself due to poverty, the petitioner has now filed the present writ petition praying for family pension and other retirement benefit. Next card, Mr. So and so, learned counsel for the Forest Department, on the other hand, submits that the petitioner's son was not a regular government servant and was only a casual worker. So as such, the petitioner's son was not entitled to the grant of any pension. So consequently, the petitioner is not entitled to any family pension. So I have heard the learned causes for the party. As can be seen from the facts of this case, the petitioner's son, who was a casual worker in the office of the divisional forest officer, Sonitpur, died due to a bomb blast on 15/8/1986. The petitioner had initially approached this court by way of WPC 3284 of 2012, praying for a direction to the respondents to pay ex gratia amount of rupees 3 lakhs, which she claimed was her entitlement as compensation, on account of the death of her husband, who was killed in a bomb blast on 15/8/1986. The said claim was made by the petitioner in terms of clause 5 of the office memorandum dated 29/7/2013, wherein it was held that in case of persons killed in extremist violence prior to 2004, but whose relatives did not apply for any appointment prior to 22nd June, 2004, and had applied after 22nd June 2004, and may or may not have received ex gratia grant under the 2004 notification, that is rupees 3 lakhs, bracket A, they shall now be given appropriate ex gratia payment as per number. So this is at page 18 of the repetition. I put it in red. Okay. First off, this court, by order dated 31/8/2016, disposed of WPC 3284 of 2012 by directing the Deputy Commissioner Sonitpur to make necessary inquiry with regard to the claim of the petitioner for receiving the ex gratia grant of rupees 3 lakhs. And to submit a report to the respondent number 2, commenting on the entitlement of the petitioner to receive the ex gratia grant. Yes, what is the report made on the basis of that?
He has granted.
So 3 lakhs granted to you?
Yes, in
Yes,
16 I granted. Extension has been granted.
The petitioner was thereafter granted rupees 3 lakhs, thereafter given the ex gratia grant of rupees 3 lakhs in pursuant to the report made by the Deputy Commissioner Sonitpur, in pursuant to the order dated 31/8/2016, passed in WPC 3284/2012. Full stop. Next paragraph. The petitioner has never made a claim for grant of family pension.
I have made better.
Where? Prior to, no, prior to this writ petition?
But that petition.
In the
also-
earlier writ petition,
No,
did
no,
you make?
No, we got these 3 lakhs after fighting this in the court.
Anyway,
They
The
never
the
volunteered to come
petitioner
up.
never made a claim for grant of family pension in any court proceeding, including in WPC 3284/2012. It is only after 36 years that the petitioner has now filed the present case for grant of family pension. Rule 31 of the Assam Service Pension Rules, 1969, provides the condition, provides the conditions of qualifying service for payment of pension. And the same reads as follows. Okay, in pink, 31. The said rules clearly provide, the said rule 31 clearly provides that the service of the employee must be under the government and must be substantive and permanent. The service should also be paid by the government. First up, in the present case, the petitioner's son being a casual worker, it is clear that his service, that his employment under the government was not substantive and neither was it permanent. As the conditions, as all the 3 conditions required for being considered as a regular government servant was not present in the case of the petitioner's son, the petitioner's son cannot be considered to be a regular government servant. In view of no, that's fine. No, this is also in line with Rule 36 of the Assam Service Pension Rules, 1969. In view of the reason stated above, no case for, in view of the case, in view of the reason stated above, the petitioner's son was not eligible for payment of any pension, and consequently, there is no question of grant of family pension to the petitioner. So the writ petition is accordingly dismissed.
Lordship, I appear for respond number 4.
Okay, Mr. D. Bora appears for respond number 4, and Miss P. You got the name? That's point number 5.
Lordship, in this case, the pension department was made integrated as a party subsequently because there was this state submission that the department has asked for a waiver from the pension department regarding the particular sum of money, 69,000 or something or other.
So who has asked for the waiver?
The department has asked the pension department to
Who-
make that waiver.
Which department?
It was MS, member MSCT about.
MACT has asked. So this excess pay was given.
Access
pay was
stay was there.
For what reason?
There was some, the AG has raised objection with regard to discrepancies in fixation of pay.
Fixation of pay was wrongly done.
Wrongly
When
done.
was it done?
The
Fixation of pay was normally done, that is why
When?
my lord, excess payment has been made.
2021.
Huh?
Communication was of 5/8/2021. By this communication, it was intimated. It may be mentioned that the grade pay of the incumbent has been enhanced to rupees 8,000 from 7,400 in pursuance of the government notification that so and so which has been look, from 2000. The date has not been given when the mistake occurred.
Anyway, you're working as what?
No,
Class?
already retired.
He has retired.
That's a
already-
different thing. Class 3, class 4,
Last three,
class 3.
last three.
So 69,000 only also, and this is a mistake committed by, and there is nothing showing that any fraud or misrepresentation was there. Then we will dispose it off.
Then, my lord, I have another prayer. My lord, he was considered, his case was not considered for modified assured career progression scheme. My lord, that prayer is also I have made in this petition, my lord.
What is
that-
their submission to that?
My lord,
First benefit, second benefit, third benefit, what?
my lord, actually, he was promoted once, so second or third.
You have to be clear, Mr.
Second
Counselor.
and third, second and third. I'm claiming for
You
second.
cannot just claim, you have got to show the
Already
dates.
he has been promoted once, my lord.
When was he promoted?
My lord. He was promoted, my lord.
You cannot do it like, you have to show me, when was
yes,
he
yes,
appointed?
yes,
When did the MACP scheme come into effect? You see, that only you have
My
to
lord,
calculate.
Lordship may kindly see page 16, my lord, that was promotion order, my lord. He was promoted to the post of UD assistant.
Page 16.
Page 16, my lord, next up to one.
But it will come into effect only from the date of your joining. When did you join?
I joined, my lord. It's there, my lord, page 15 is the joining. Appointment letter, I think that is the joining. 15,788.
Page 15?
15,788 he joined.
No.
My lord. After promotion, my lord. Here in India.
Show me the MACP scheme. When did it come into effect?
Lordship may kindly come to page 31, my lord, MSCP scheme.
Yes.
And my lord,
Where is the relevant portion?
my lord.
It came into effect from, Mr.
relevant
Council,
page is my lord,
this came into effect. From six,
relevant page is my lord, financial page is my lord, 32, my lord. First line, financial benefit of the scheme shall be given effect only from 1/1/17.
then
So
is this,
after
is this,
1/1/17,
huh?
after 1/1/17, my lord.
Will it take retrospective effect?
My lord.
Will this scheme
Yes,
take
yes,
retrospective
that
effect?
paragraph is, my lord, may I read that paragraph, my lord? The financial benefit of the scheme shall be given effect to effect.
Where are you reading? Which page, which paragraph, where?
Paragraph, my lord, page is 32.
32.
32.
Yes.
That is the, my lord, paragraph number 7, the first paragraph, that is the, my lord. The financial benefit of the scheme shall be given effect only from 1/1/17. However, the service rendered by the employee before 1/1/17 and promotion ACPS benefits availed before 1/1/17 shall be taken into account for deciding and determining the extent of benefit under MACPS.
When did you retire?
My 34/2020. 34/2021.
Rakesh, just fall. Just walk. Yes.
Page number 17, my lord, annexus 3, my lord.
No, you tell me,
My
Mr.
lord, he
How
retired from service, my lord, 34.
You have to calculate how many benefits. Are you supposed to get the first benefit, third benefit, second benefit? Which one?
Second and third, my lord. That's
Why?
not me, my lord.
Why?
Because, my lord, he also got already one promotion, my lord. That is why, my lord, he has completed more than 30 years, my lord, service. That is why he is entitled to second and third benefit.
Might not be correct, right? You just think about it. I'll just come 2 minutes.
My lord.
Yes.
Well, I, another letter, Lordship may kindly see at page 49. There is a letter from the presiding officer, that is my appointing authority, presiding officer, member MACT Nalbari.
Yes. Regarding the MACP,
MACP and so far as MACP is concerned, I don't have any clear instruction.
so you get that instruction.
I need to, I have written also, but that instruction did not come in the previous occasion. Some short case, I'll try to get the instruction. Otherwise, so far as recovery is concerned, that law is settled. There is no.
So I since you all are taking a decision anyway, we'll wait for your decision. Because I thought we'll dispose it off. But since he has brought up the issue of MACP, appears that he is entitled to appear, I don't know, prima facie, maybe maybe
But so far as
two benefits.
I found one document in the repetition pleadings wherein it has been, AG has written to the member MACP saying that from 2017 he is entitled for second SAP and 2013 he got one promotion. If after second
That's what
SAP,
he cannot get. He cannot get
cannot
beyond
get
second.
third
No,
SAP.
third there's no. He's wrong. That much I'm quite sure. That's why. Yeah, you have to be very clear.
Second SAP 2017 he is
There's
entitled.
no question of getting the third. But then you just find out.
Yes.
You just
I-
get
specific-
positive instructions.
Yes.
Okay, right. Mr.
CS Hazarika.
C.S. Hazarika submits that the question of recovery of the excess payment made to the petitioner has been put to the
Pension and public grievance.
has been put to the pension and
Public grievance.
public grievance department, who will take a call on the same. The counsel for the respondents shall also obtain instructions with regard to the petitioner's second prayer regarding his right to receive the second ACP.
Third SAP.
Second
Second.
ACP. Second ACP. Under the MACP. SC. This is a matter after 3 weeks.
Copy of the, once the pension and public grievance department was implemented. I'll start.
My lord, instruction is awaited to file affidavit, my lord. Further 2 weeks time may be granted, my lord.
Lordship, it's a very simple case. The petitioner is asking for his arrear payments, allowances, as well as any increments. First, he was suspended, then he was reinstated. And reinstated on the basis of judgment of the CGM courts.
Any citations in your favor?
My lord, it's already annexed, my lord. My lord, it's in page 24 to 26, as well as 27 to 30.
Yes, please read.
If an employee is put under suspension because of any criminal proceeding,
Page.
my lord, 24,
Okay,
towards the last.
yes,
If an employee is put under suspension because of any criminal proceeding and no separate departmental proceeding has been drawn up, and thereafter he is reinstated on being acquitted by the criminal court, he is entitled to get full salary for the period of suspension, even if acquittal is on the basis of benefit of doubt. My lord, this was not even on the basis of benefit of doubt. He was
and the next judgment,
on the charge.
next judgment,
Lordship, it's from page 27 to 30.
yes. Please read.
The relevant para is, my lord, in page 30.
Yes,
We accordingly allow this appeal, set aside judgment and restore the one trial, and this part is said in. My lord, the relevant part is in page 28. The appellant was a permanent UDC, who is already retired on superannuation, must receive measure of socio-economic justice and so. Was paid full salary in question. Had not held that suspension was wholly justified because of 3/4 salary transfer. It must be held that in this case, full amount of salary should have been paid to the appellant on his reinstated for the entire period. It refers to para 6 of the judgment. And even in this case, my lord, there was no departmental proceeding against the appellant.
yes,
But facts and circumstances are little different in this
how?
case, my lord. Even after acquittal, my lord, the petitioner did not inform the authority for maybe 20 years. It's clear in the speaking order, my lord. It pays 23, my lord. Annex RF.
Page 23,
Yes.
yes,
Whereas by the order dated so and so forth,
page 23,
yes, my lord.
yes,
Annex RF.
yes,
Order dated 16/7.
Order dated 16/7.
yes, please read.
Whereas on acquittal from criminal charges in connection with so and so forth, case number, CGM Kukradar, as per approval of the Secretary Agriculture Department, Kukradar dated so and so forth, Sunil Kumar Das, peon, was reinstated in service in the interest of public service in his original post, height so and so forth, dated so and so forth. And accordingly, Sri Sunil Kumar Das has joined in his service on 31/12/2016 by so and so forth letter. Whereas on perusal of Learned CGM Kukradar order dated so and so forth, DS letter dated so and so forth, and other connected documents, etc., based on the facts and circumstances mentioned above, the undersigned being the competent authority in respect of the incumbent subsistence allowances will be limited to the allowances he has already been drawn during the period of suspension. Accordingly, admissible pensionary benefit, etc., except leave encashment benefit may be released to the said incumbent, and with above directions, the departmental proceeding pending against Sunil Kumar Das PM is hereby finally disposed of. Whereas as per record.
Lordship, the petitioner has already so caused to show reasons why he did not inform the authorities, and he already replied to that, and pursuant to that, he was reinstated. So my lord, they already considered all these matters, then he was reinstated. And my lord, kindly have a look at the last paragraph of the same order. My learned senior colleague has already referred, page 23. The last
No,
paragraph.
no, so you were acquitted by order dated 98,
My lord,
correct?
my lord.
Now, why were you reinstated only in 2017?
My lord, because the petitioner was waiting in anticipation of order of reinstatement.
Ah,
And because he was already acquitted, so he was under the bona fide belief that the order will be conveyed to the authorities.
Ah.
So the authorities, however, served him a suspension order after 16 years.
When?
In the year 2013, 24, 10, 2013.
Date
24, 10, 2013.
2410,
My lord.
20?
4, 10, 2013.
Where is that suspension? Where is the suspension order?
No, it's not a net.
Hmm?
Okay. Not a net.
Why haven't you annexed?
Because my lord, thereafter he was again sent a show cause, which we had replied to with annexed.
Where is the subsequent show cause?
My lord, it's in page 19. Sorry, my lord, page 19 is the first show cause. This one.
Who is Sunil Kumar Das? That's you.
My lord.
Then page 19 is a reply to the show cause. It's not a show cause.
No, my lord, it's two Sunil Kumar Das.
What?
Page 18.
No. You look at page 20. Yours faithfully, Sunil Kumar Das.
My lord, it was not clear in my petition. Apologies. It's page 18, my lord. No, 19. 18. I apologize.
Page 18 is first show cause.
My lord. This was served after he was already acquitted. This was served after 16 years of his acquittal.
Now they say that you have failed to inform.
Order of acquittal was not communicated.
Not communicated. So why should you be paid
My
for
lord,
the
then I
amount?
already replied. Then they
No
considered
work.
my reply, and on the basis of that, they reinstated me. So
Let us see how is the ground.
my lord, my reply is in the
No
next
work,
page.
no pay. Why should you be given money for not working?
My lord, even if my lord comes to page 23, in the speaking order which my colleague had already referred.
Yeah.
My lord, last para.
Yes.
1, 2, 3, 4, fifth line, my lord.
Yes.
It says this has decided that a period of suspension may be treated as on duty. So since his period was treated as on duty, hence my lord, he's already entitled to, because his period was treated as on duty. So when he was on duty, so he's already allowed He's already entitled,
When was your suspension lifted?
Lordship.
You kept quiet for 15 years. You did not try to go to work after you're acquitted.
No, I was like in the good.
Huh?
After acquitted.
You were acquitted in 1998.
Yes.
But you did not inform your authorities that you were acquitted. That means you did not even try to work, go to work. You should have gone to work. Anyway, you filed. Yes, Mr.
Yes, SR Rava.
S.R. Raba, Learned Standing Council, Agriculture Department is granted 3 weeks time to file affidavit in opposition. This is a matter of the
Like.
Item number 19.
May I please your lordship? My lord, in this matter, on last occasion, we have filed one affidavit at page 72, my lord. In that affidavit, we have stated that, my lord, on earlier occasion, we sent the proposal along with the draft service rule to the finance department. Then they sent back the file to us with certain queries, my lord. Now, my lord, yesterday I have received the instruction that after meeting up those observations made by the finance department, now it has been resubmitted to the finance department.
You please give us the draft rules.
Draft
Show us
rules,
the draft rule.
that is the draft rule because we are not provided, because that is the.
So we are asking you to provide. You ask for it. Whether we'll call your secretary, we will ask him to provide it. You call it from the finance department.
Yes, my lord, that may be called for that, because now it has been moved to the finance department.
Arre, what is so difficult for getting a photocopy of your draft rules?
Yes, my lord.
We want to see whether you are playing around with the court or not. Right. Mr. D.P. Bora, the learned counsel for the health department, shall produce the Assam Nursing Service draft rules of 2023, which has been sent to the finance department in terms of the letter dated 16/11/2023 issued by the Joint Secretary of the Government of Assam, Health and Family Welfare Department. The draft rules shall be produced before this court on. When can you produce?
Any day, your lordship, a reasonable time may be granted.
Give a date. December.
Huh?
13 December. First of failure to produce the same may entail the presence may require the presence of the Joint Secretary of the Government of Assam Health and Family Welfare Department, who issued the letter dated 16/11/2023. This is the matter on 13th.
His lordship, the petitioner has been 37 years served, but his promotion is not given. But as per scheme, my lord, he is entitled. But page 35 in this scheme, my lord. Assured career progression scheme, page 35, my lord, 34, my lord, and relevant is 35 column 4. And it is after 10 years, one promotion or upgradation of financial, or after 24 years, second.
Yes, what is to be done, Mr.
My lord, we are yet to file our affidavit in this. I need some time, my lord.
Mr. R. Khan,
He has retired also in 2004.
Retired, my lord.
Mr. R. Khan, learned counsel for the
PWD, my lord.
PWD, and Mr. R.K. Talukdar for the respondent number
4, my lord.
4 are granted 3 weeks time to file affidavit in opposition.
Our affidavit is not actually, my lord.
Okay, you just put R.K. Talukdar. Put that.
That may be fixed, my
3 weeks
lord.
time.
Mention that.
Next. Other cases are there, Mr. Counsel. Otherwise, we give dates only to your cases. Those other cases will not come.
I know. 27.
Yeah, my lord, I'm awaiting instruction from the government, my lord. Proposal has already.
You have got instruction.
No, my lord, I'm awaiting from the government. I have, proposal from the director has already been submitted to the government.
Mr. N.J. Khataner, Learned Counsel for the School Education Department will be granted a further 3 weeks time to file affidavit.
Obliged.
May I please, Your Lordship? In this case, my lord, affidavit filed by the my lord state respondent, we have received and we have filed a reply to that, my lord.
You are going to file reply.
Already filed, my lord. Lordship can take up the matter, my lord, today. My lord.
When? Now.
Now, Your Lordship can take up on it. Lordship, kindly come to page 70.
Just a minute.
Page 17 is the advertisement with regards to appointment of LP school, my lord, lower primary school.
No, what is your case basically?
My lord, basically what happened, petitioners, an advertisement was given on in the year 1996. Thereafter, a select list was published, and in that select list, petitioner was appointed along with 2 others, my lord,
As what?
as LP school, primary school, stipendiary primary school teachers, after regular recruitment. Then, my lord, what happens? Thereafter, petitioner receiving salary, and he was on her request, she was transferred from one block to another block. That is what my lord crux of the matter. In the other block, what happened, my lord? There is an allegation by the government that, my lord, some, my lord, persons were appointed against non-sanctioned post, non-existing post, my lord. I am not on that. During the course, my lord, I have passed the, my lord, basic training course, and thereafter my service was also regularized. From once I was transferred in that other block, my lord, I received salary for some years. After the from 2012 onwards, I am not getting salary. So far as the affidavit filed by the state government.
So your claim is payment of
Salary, my lord,
from 2012.
12 onwards. And I am regularly appointed. Yes, I admit the fact that there are illegal appointees in that area. So far my appointment is concerned, my lord, I was regularly appointed pursuant to advertisement. I have applied through Treasury Salan. I have annexed, my lord. Thereafter, 3 persons were appointed in against sanction post. Against sanction post, we received salary. Out of these 3 persons, I was transferred to another block because of my merit. Because of my merit, I was transferred to another block. From there, my similarly situated person are also getting salary, my lord, receiving salary till date. Those who are appointed along with me, page 21, my lord. They are receiving salary. 3 persons were appointed pursuant to selection. Though in those appointments, there is no advertisement, there is no selection, there is nothing as such, only appointment is there. With regards to my petitioner.
Okay, we understood. You are the only angel among a sea of devils.
No, yes.
So then now what is your, so you want your pay since you have not been getting it?
Yes, my lord, that is what. They have filed affidavit. They have not.
We have filed our affidavit lawsuit. The petitioners also comes under that illegal appointment lawsuit. Subsequently, in terms of the cabinet decision, the screening committee was formed. Lawsuit. The petitioner appeared in the screening committee as per our affidavit lawsuit. And there are certain criteria in terms of the cabinet memorandum lawsuit that petitioner did not come under that criteria. Therefore, the petitioner has not been accommodated either as a teacher nor as a tutor lawsuit.
Lordship, kindly see their affidavit, lordship.
So his service was terminated or what?
No lawsuit. The service was not terminated lawsuit.
She is working. I have working certificate annex.
The appointment itself was illegal lawsuit.
They never say. They never say.
Lordship, we are going to file another additional affidavit from the secretary office, lordship, because the affidavit has been filed by the director, lordship.
Lordship, kindly see the affidavit they filed.
There in the office of
Let them see. There's no point hearing you all when the pleadings are not complete.
It is complete. They have filed affidavit.
They are saying that they want to file additional affidavit.
Now again, my lord, and I have filed reply to that, my lord.
When you file additional reply,
we are going to
give you
file
time.
But petitioner is, my lord, without saying she is working, my lord. What?
Mr. Counsel, this case was filed in 22.
Lordship.
You have survived without pay
For 10
by
years.
eating grass, most probably, for the last 10 years.
Lordship.
Why can't you wait for another 2 months?
Lordship, kindly see the affidavit they filed.
What is your, so his service was terminated or what?
Lordship, kindly see the affidavit they filed.
Lordship, my lord, short date maybe there, my lord, so that they can file affidavit. I am not objecting to that.
You have come to this court after 10 years. Why can't you wait for another 2 months? You also, there's a delay. What were you doing? How are you surviving without pay for the last 10 years?
And the petitioner appeared before
That is
this.
the-
Huh?
From other sources, she is surviving, but she is
Other
entitled.
sources.
My lord, she is otherwise
Ah.
entitled. Her husband is also teacher, my lord. Otherwise, she is entitled, my
Anyway, but the thing is that you have waited for 10 years, you wait for another 2 months.
Mayor making a submission that I am a irregular appointment will not do, my lord.
That is why we want to see, but we could make a mistake.
Yes, my lord.
If we decide a case on the basis of incomplete pleadings.
Yes, ma'am. In that case, my lord, finance department is also a party, my lord. Then they should also file affidavit, because on the next day they will appear and they will say, no, we have not filed it.
Probably. Yes. Are you filing, Mr. Chalia?
Finance department is party here.
Lordship, if required, we'll file the affidavit. Lordship, let us receive
They are the party, my lord.
Lordship, we'll file it. A date may be given if required. Otherwise,
Respondent
we'll put
number-
an affidavit saying that we don't need to file an affidavit.
Respondent number 2 and 5 is the, my lord, finance department.
But finance department's role is not there.
Not their loss.
My lord, role is there because,
Why?
because they are saying my appointment is against non-sanctioned post. And they are not, finance department has paid salary to me, my lord. Treasury office has paid salary regularly.
This is arrears
All
and
along, my lord.
salary. Lordship, if I may make the submission.
And the person similarly situated, I have annexed the document, they are getting salary.
That is the
Can
call
I-
of the
same
education
request.
department.
Let me hear the other side also.
That is the call of the education department, Lordship. They have the budget to pay the current salary as well as the arrear salary. And if they are disputing, only then, if they have, Lordship, if the views of the finance department will be
Anyway,
required only.
If finance
Right,
department is
Mr.
not agreed to file
Mr.
affidavit,
Yes,
then what?
P.S. Sharma, learned counsel for the elementary education department submits that the secretary to the government of Assam elementary education department would like to file an additional affidavit. She's accordingly granted 3 weeks time to file the additional affidavit. This is a matter of the 3 weeks.
Lordship makes a fixed date after 3 weeks. Please.
Next.
Oblige. Lordship, in this matter, I am appearing for a respondent water resource department, Lordship. I am giving some time because some developments are going on in favor of the petitioner's, Lordship. So may I pay for 3 weeks time at this time?
Okay, right. On the prayer for adjournment made by Mr.
RM bus,
R.M. Das, learned counsel for the
water resource department.
Water Resource Department, who submits that some developments are taking place
Lordship.
with regard to the present case. List the matter after 3 weeks.
Lordship.
Much of it.
Your Lordship. In this case, your Lordship, the petitioner are retired professors who have retired as professors of different colleges. And they, in terms of the order passed by this honorable court in WPC 61 of 2011, they are entitled to get the arrear pension which accrued to them because of the remission of pay. But since they were not given, they approached this honorable court. On the last occasion, it was said that a review petition was filed against the earlier order on the basis of which we are claiming. Now, this review petition has been dismissed in the meantime. It was filed by the government. But this review petition has been dismissed on 14/3/2023. The finance. One fifty of 2018.
Lordship, because Lordship from my, what I can see is they were, uh, uh, because the executive, the administrative department will have to take a call regarding if there is any pay anomaly finance. That has to be considered by the administrative department. Government lordship, government.
Pension and public revenue.
Education. Then they were all instruction of one. Here, Lordship, these are employees of colleges and all, my lord, so. Yes, my lords, so, and they have not been made a party, my lord, because. And review, Lordship, I apologize, Lordship, I don't have the review.
Review filed by the government.
No, which
This order is there. I
government, Lordship may.
This review has been dismissed.
Lordship, can I, Lordship, have a look at the.
It may be fixed, let him take.
The Lordship here, this was filed by Mr. R. Pujari, my lords, he is in bereavement, my lords. No, yes, Lordship, the instruction, updated instruction only he can place, my lord, because. Actually, Lordship, I think there is an appeal has been filed also. That appeal was filed today itself. Lordship may just have it next week, Lordship, because all of a sudden. Yes, Lordship, this has been Lordship, I'm not in a position because Finance Department. Yes, sir. Lordship. Lordship to 4th of December, Lordship.
Oblige, Lordship.
On behalf of BPC, will I pay for 2 weeks time to file my affidavit?
Let earlier also, let they took time, let transport granted time. But it's not fine. Let me actually for a date, my lord.
Please, Your Lordship. Lordship, we have received the instruction kindly 3 weeks time may be given to NN Sharma. 3 weeks time may be NN Sharma. Behalf of K. Gogol, Lordship, for CGC. CGC. For all the respondents. 3 weeks, Lordship. Okay.
Lordship instructions issued, Lordship, I need some time to file my affidavit. Lordship, we have submitted everything to the AG, Lordship. Yes, Lordship. Let me file my affidavit, Lordship. Let it be on record, Lordship. A week's time may be granted, Lordship. No, yet. The Upamanya. Not yet. Not yet. 29. Oblige.
In this matter, Mr. Diego is appearing a lordship. He's currently it's not well, your lordship. So may I pray the matter be taken up on Monday, your lordship?
My lord, this case. My lord, this is covered case, my lord. Of course, my lord, if my learned friend taking time, my lord, 1 week, after 1 week. My lord, 28 or 29 minutes.
Oblige, Lord.
In this matter, we need some time to file the affidavit. Yet you said.
So let's see, book is not. Not. And that's probably the 33 probably, time put. Last.
Retrieving, my lord. Herein, my lord, they are basically
In the section 19, section 19 lodge. Say lodge. When an employee fails to pay the gratuity due under the Act in accordance with the notice by the controlling authority under Rule 17 or 18, as case may be, the employee concerned, his nominee or legal heir, as case may be, to whom the gratuity is payable, may apply to the controlling authority in duplicate in Form T for recovery thereof under Section 8 of the Act. Section 8 of the Act. Lordship. Section 8 lordship, recovery of gratuity. Lordship. If the amount of gratuity payable under this act is not paid by the employer within the prescribed time to the yes. Lordship, it has to the under section 17 lordship if application file and it is not considered lordship, then lordship the person has the right to lordship recover.
Yes. Basically, check in the pension minimum that is yellow. If I remember, pension minimum. Pension minimum. Losing pension minimum that is yellow. In pension minimum it is yellow. I have lost. Cash check is yellow, sir. Provision is yellow. Lawsuit. The provision under section 17 lawsuit application is filed, is not considered. Lawsuit, tomorrow it may take an approach. I'll satisfy lawsuit. Tomorrow lawsuit. Lawsuit. I'm sorry, lawsuit. I'm sorry, lawsuit. I thought lawsuit there is either lawsuit there is strict time lawsuit or lawsuit there is final hearing. I'm sorry. In pension, I have gone to lawsuit. Yes. Section 8 is there also recovery and section 9 was made mode of payment and 17 is there also provision. The procedure has to be followed. So if you go by section 4 is there also. Section 4. Let's see, section 4. Yes. Yes. For the calculation, I have remembered in different case I have given, but unfortunately I have forgot the section. Can take it after something. Lots after something. Lots. Yes, sir. Provision, yes. Last on base. Determination. Last on base. Lots. 4, 5, 6 all assemblies. 34, 35, 36. Large.
He's a member of the RPF Miller, was transferred in violation of Directive number 58. After that, what? Annexure 1, page 17, serial number 42. And main part is start from 42. Ramia from Alipurduar. Well, it's a in violation of Directive number 58. After that, what happened, Miller? Yes, please. Directive is at page 20. The provision which has been violated, Miller, is at page 28. Roman 19. Yes, sir. The process of annual transfer, all annual periodical transfer.
Page 28.
Page 28. 19.
It's 19.
Page 28, Roman 19. The process of annual transfer. The all annual periodical transfer shall be processed in the month of January every calendar year and completed on or before 15 March or before end of local academic session, whichever is earlier, so as the officer and staff so affected could get sufficient time to plan for settling of their families and admission of their works, as the case may be. It has been violated, and thereafter, Your Lordship, kindly see page 29, Roman 29. Page 29, last paragraph. Page 29, next page. The last paragraph. The entire process of periodical transfer, including sparing and joining of the members of the force at the transferred place, shall be mine. It has been violated. Therefore, what happened, my lord? They have given exemption. Your Lordship, kindly say Annexure 6, page 59. 59, 59. Yes, ma'am. Reference above. One-time exemption has been granted for completion of periodical transfer of RPF personnel till 31st July 2023 in place of 30th June 2023 for this financial year of 2022-23. The date of start of the tenure shall be deemed to be from 31st March 2024. The exemption was granted. Even then, no action was taken. 24. Yes, ma'am. Thereafter, Your Lordship, can you say no action has been taken, my lord? I was forced to join that place of post. Thereafter, my lord, being aggrieved, some of the petitioners has filed a writ petition and the transfer order has been suspended. Yes, my support. Yes, ma'am. Thereafter, my lord, it was challenged and it has been suspended by some other similarly situated candidate. Annexure 7. Your Lordship, can you see page 64?
In fact, Lordship may kindly take up the next case first. This is 5107. Lordship 4744 is the base case, Lordship. Few are the similarly situated persons had approached this honorable court against that writ petition, against the order of transfer, Lordship. This is in fact, Lordship, 5-6 case. Item 39, both are important, but 39 is first lordship. In fact, 40 perhaps has become infractious.
I repeat.
B. Sharma. Lordship.
Yes.
Dear Lordship, this challenging the same transfer order, these few petitioners have approached this honorable court by filing this writ petition. And honorable court had granted one interim order, Lordship, suspending the transfer order, Lordship. And now these other writ petitioner of item number 38. He is not a writ petitioner where the interim order was granted, Lordship. And in that order, Lordship, it is specifically mentioned the petitioners who are before your Lordship, their interim order has been, their impugned order has been stayed, Lordship. This petitioner was supposed to join prior to passing of the interim order to his new place of posting. He had not approached this honorable court, neither he had, yes. Lordship, Lordship. Yes, Lordship. Yes, Lordship, yes. Now, Lordship, on 9/8/2023, there is an order that this petitioner of 38, I don't know, 38, Ramesh Chandra Roy, he is unauthorizedly absent. Neither he had on leave nor he had approached prior to issuance of the interim order. So he was unauthorizedly absent from 25/7/2023. But Lordship, this that order is of 31 Lordship, 31/7, and he was unauthorizedly absent from 25/7. But before exemption, Lordship, before this exemption, yes, yes. Now he is seeking similar relief. 38 is later on, Lordship. 38/2023. After the interim order. Now, after the interim order in similar case, he had approached this honorable.
What happened, earlier there was another writ petition where the railway board standing council has clarified that the exemption which is issued by the railway board, the effect will be given from 24. So I was in the impression that the effect will be given from the year of 24. Your Lordship, kindly see page 57, paragraph 12. During the deliberation of the matter, Ms. B. Sharma learned Central Government Council placed before the court a communication of the Railway Board, Ministry of Railways, Government of India, under number so-and-so, dated 31/7/2023, issued by the Deputy Inspector General, Establishment Railway Board, communicated to all the Principal Chief Secretary Commissioner, RPF, all Zonal Railways of India pertaining to the said Directive number 58, issued on 13/3/2023. Noted above, clarifying that the Railway Board in the Ministry of Railways, Government of India have granted one-time exemption for completion of the periodical transfer of Railway Protection Force personnel till 31st July 2023 in place of 30th June 2023 for the present financial year of 2022-23, and that the date of start of the tenure shall be deemed to be from 31st March 2024. And because of this, Miller, the repetition was
no.
No. I was not a party, but the Your Lordship kindly say the exemption letter.
31/7,
7.
23. He had to join by
I was-
25/7. From 25/7, he is absent. He had to join his new place of posting prior to this.
No, my lord. After the interim order, my lord, I was spared. After the interim order passed by this court, my lord, in 4744, 39, 39. No, I am not, I was not referred. But the only thing is with that, my lord, exemption was granted, my lord. And because of this, my lord, the earlier case has become infructuous because of that exemption, my lord. The same footing, my lord. Your Lordship, can you see the next page, 58?
Now, that
No, my lord,
instruction I do.
I'm
Where
on
is he? I
medical
do.
leave.
He's
Leave. Yes, ma'am.
because one thing is there, Lordship, at that time when WPC number, Lordship,
Yes, ma'am. Yes, ma'am.
Lordship. Lordship. Leaving apart that also, Lordship, but he is seeking similar benefit, Lordship, but he was spared prior to issuance of this interim order because those petitions, this here, Lordship, although the 31/7 order is there, Lordship, subsequently the here railway authorities have spared them. Some miscommunication is there, but although that 31/7 that exemption is granted, some miscommunication they have spared them. So they other sets of. No, he had nowhere joined. He is on leave. Because he has to join, Lordship. That Lordship, that he Lordship, that on previous order also reflected that on the very first day also I have submitted that instruction, Lordship, that he has to join. Yes, Lordship, the same.
Item 39 minutes, the issue is same minute we have challenged and the transfer order has been suspended. The same transfer order. The petitioner are different. No, my lord, what happened, my lord, because of the submission made by the railway board, my lord, another petition was there, my lord, that has become infructuous. But even then, my lord, no action was taken. Therefore, being aggrieved, we filed another writ petition. And in that writ petition, my lord, the post order has been suspended.
Transfer order has been suspended in item 39, Lordship. Yes.
Same.
38, petitioner of 38 is seeking similar relief like that is passed in item 39. 38 is later on. 39 is the previous order where this transfer order, sparing order was suspended, Lordship. And Lordship will get the order is there, Lordship.
Yes, next.
On the check, but yes. Lordship.
Yes.
No, my lord, what happened, my lord, even after the order, they have not allowed us. Therefore, being angry, we filed another writ petition. Thereafter, only our case was considered for joining it, for allowing to join in our previous respective place. Yes, my lord. Yes.
The other person has joined, so 40 becomes infractious.
We have,
No,
in the meanwhile,
39
we
and
have
40
joined.
same petitioners. Same petitioners.
40 is a writ petition.
Yes, almost, because up to 31/3/2004, now there is a suspension order by this honorable court. But on 31/7/23 order is there, yes. Lordship. This.
I refuse. Yes, my lord. In item number.
No.
24.
31st March 24. Page 28 and 29. They are already joined. They are working. No, not gone up.
Yeah. 30.
B. Your junction. No, no.
No, my lord.
His
Was
earlier post. He was
Romgia is my present place of work. Alipur the present place of work. Where it was.
Made your lordship. Petition basically two pairs, my lord. First pair was the challenging the suspension order. Second pair in suspension order, they did not mention any subsistence allowances. And honorable court by interim order, my lord, earlier present, honorable court directed to pay the subsistence allowances. As per instruction, now he has got the subsistence allowance. Now regarding his suspension is concerned, my lord, they did not file an affidavit, but an affidavit is required. There is a disputed because of that. There is a date of dispute of the suspension order, my lord. Yes, my lord. First thing is that yes, there is a criminal case against me. I'm arrested and I was released on bail. And thereafter, my lord, more than 1.5 months, thereafter they suspend me, my lord. My lord, with release on bail with effect from date of arrest. And but in this particular suspension order, they stated in that is very important 4.4 in my suspension order, but they did not review within 90 days. So thereby we came before the honorable court. Honorable court on instructions, he says that suspension order was okay, review was done, but he did not communicate it to me. And thereafter, my lord, last 2 days before, they communicated to me. But this suspension order, this review is also very defective because of the indefinite period. It cannot be review cannot be indefinite period. It's Supreme Court as well as honorable division bench also. My lord, is review is done, my lord, by reason order as well as within periodical review, but they did not. So my fear is that, my lord, their affidavit is required and I file reply and thereafter argument is going on. I was released on bail on, my lord, this may kindly see. I was released on bail on 25/4/2023. Yes. Yes, my lord. That, my lord, thereafter, my lord, and suspension order was issued on 4/4/2023.
When was inside only, my lord?
Yes. And that was not communicated to me, and thereafter I was received it. And my lord, I file an immediately, my lord, I file an review undertaken, my lord, just 3 days before we received by WhatsApp, my lord. They said on 5/4/2023. 5/7/2023. Yes, madam. But there is no any reason. Yes, madam. My lord.
Yes, my lord, there is subsequent review, my lord. Just I have placed, my lord. Before that, my lord, DP has been initiated, show cause notice. He has filed his reply. He has, my lord, DP case number 1 of 23, my lord. Show cause notice was on
That
1/6/23. And he has filed his reply on 12/6/23. 12/6/23, he filed his written statement.
Reply.
Yes, my lord.
No any pilot there.
Now, my lord, if you go by he is harping on Ajay Chaudhary, that is what I read in his synopsis. Now, my lord, if you go by para 22 of the Ajay Chaudhary judgment, my lord, once show cause notice is given, DP starts, my lord, that 90 days period, my lord, will not come into effect. That is what Supreme Court said, my lord. If I may read, my lord.
Yes, judgment is there.
So far as the fact of the present case are concerned, the appellant has now been served with a charge sheet, and therefore these directions may not be relevant to him any longer. However, if the appellant is so advised, he may challenge his continued suspension.
Yes.
So let him, my lord, challenge it, my lord.
I challenge it.
Not here, my lord.
My lord, before that, my lord, he did not read it, my lord, in paragraph, my lord. Please may kindly see.
That is all gone, my lord. Once.
No. You cannot read it one. You go to the whole judgment. And there is a division bench order regarding that issue. Your lordship also passed the order. It's clearly said, we therefore direct that the currency of suspension order should not be extended beyond 3 months if within this period memorandum of surcity is not served on the delinquent officer employee, comma, please then you read.
Continue.
If the memorandum of surcity is served, a reason order must be passed for extension of the suspension. So what reason order has been passed? And my submission is that, my lord, they did not pass in reason order within the period of 90 days. And this reason order was, now says the review was passed, but they did not communicate it. If they did not communicate it with me within that period, that suspension review will go as per Supreme Court judgment, my lord. I brought it. My lord, my lord is clearly says in 19, my lord, 69 SCC, my lord. So regarding that issue is further. So thereby, that if they did not communicate with me in within that, yes, but the community review, my lord. Review order or suspension order, anybody, the suspension order was set aside. It is not communicated within time, my lord.
Review is
My lord,
here.
my lord, is Supreme Court clearly said another judgment, internal routing cannot be treated as communication, my lord. He kept in file and review in his file, but they did not communicate. Thereby, why am I coming before this honorable court to regarding that issue? They did not review me. So let them file affidavit, I'll file reply, and their argument is going on, my lord. I own that. Yes, my lord. Even suspension order also not communicated to me. I am going to take a photocopy from the office. It's very unfortunate for me. Because of that, they suspended me as a punitive.
When he was suspended, he was inside the jail. He cannot expect that authorities will
definitely
go with a suspension order and deliver it to him in the jail. It is his duty once he is out of the jail on bail, my lord.
I am honored that I am going to review his concern. This Honorable Court specifically earlier occasion stated when it was received. My lord. Earlier order. Review order as per my instruction, my lord. My lord. Now regarding his suspension is concerned. Suspension and the suspension related to review. Because of that, first I was suspended. There must not whether this suspension is necessary or not. Extension of my suspension. They did whether it's extended or not. On what purpose they are extended. But this is. But within 90 days, I'm going to that money. If 90 days is but done in 2 days before, my lord. On 14/11/2023.
My lord, it was done on 5/7/23. It was the review of extension of suspension issued.
Yes, issued on 5/7, but it was received on 14/11 after passing this honorable court. The honorable court specifically stated. If my suspension is on 4/4, then within 90 days not good.
The effect of 90 days will not come into effect, my lord.
Well, they may come on oath, my lord. I am not going to talk that, my lord.
Once
They may
DP is
go on
initiated,
oath.
my lord, the law is very clear, my lord. Once it is initiated, that 90 days thing will not come into effect.
Within,
That is the irony of Ajay Chaudhary
no,
case, my lord.
well,
He
review
never got
should be
any
done
relief.
within 60
He
6
never got a
months,
relief
my
from
lord.
this order. But
Periodical
lot of people
review.
got, my
It
lord.
cannot indefinite period, my lord. Periodically they can review that till 6 months, and thereafter again they may review as per their notification is also there. But today, well, I'm not there. But their review is done, but they say that till conclusion of the departmental proceeding drawn against whatever is earlier. That is punitive. That is punitive, my lord. My lord. Yesterday I am caught by mobile. There is a judgment, my lord, justice. People matter. There is a their notification is there. No. This is no. Yesterday your lordship was 2900. My lord Justice D. Borua, my lord Justice Borua. There is a their memorandum, office memorandum within 6 months. My lord.
Review that there is a OMN.
But just now I have got it.
6 months. Over.
No. That's why I'm saying no. I'm not on that. No. 6 months. That means key. That means review for only 6 months. And they are periodic. What is meaning by periodical? Supreme Court clearly said the suspension should be reviewed periodically. What do you mean by it? First 3 months, thereafter 6 months, thereafter they says that my lord. That was received on 14/11. Yes, but they did not this review. Please you go through this review. What they say. No, yes. So I am going to that matter. They may file oath on oath. There is a dispute regarding this. That is concern is also suspension. That is very important.
My lord,
I think all are going to
I am on
subsequent
Ajay
matter.
Chaudhary, my lord. Once the DP.
I am going to on
initiated,
record. He may go to on record by that. Because of that, I am suffering.
That is what maybe.
Maybe, but I am going to on record. Well, at least they will file affidavit and I will reply. Well. Because of that, my lord, my first case, yes, my reputation is they did not review was not done. Because of that, I was not communicated. So they came for down a report. But that review must be region order. Region order. Without region, my lord. Yes, my lord. Without receiving on that, how the 2 days before? Yes, my lord. That's why their record is necessary.
Fresh petition. That is what my lord.
My lord.
Fresh
My lord.
petition. Different
Yes,
cause of action. That is what Supreme Court said, my lord. That is what Supreme Court said, my lord.
Yes, my lord. My lord. Definitely. But I also going to I'm going to give the instruction to go file another petition along with that. Because of that,
But
suspension as well as the review, my lord.
This has to go, my lord. Yes,
My
my
lord,
lord.
and on the other hand, my lord, if your lordship is going to dispose of that, my lord, I file an appeal, my lord, that was not disposed of. That can be order, my lord. For review, for revocation of my suspension.
That is always there. He is all over.
That can be.
My lord, then my lord.
Why he is going to problem?
No, my lord. My officer will come into, as per law, my lord. My lord will observe that he may file an appeal
already filed
before the authority, and they will dispose it, consider it, my lord, with the provisions of law, following the provisions of law, my lord.
That was filed, my lord, for personal, my lord. Case 34, my lord. The representation was filed for proportional manner to the deputy commissioner. Yes, madam. There is a notification, but today, man, just this order has been passed by the, there is a specific paragraph, my lord, 5, my lord. Allegation is, my lord, I am taking a bribe of rupees 5,000. This is the, but that is very pathetic.
It's a anti-corruption case, my lord. SCB PS case number 20 of 23. Under
para 5, my lord.
My lord, may I have instructions, my lord, he put some light, my lord.
কেতিয়াবা এইফালে আইডিটো সদায়তো টাটা থাকো এইটো মই জানো তো দিব নালাগে এইটো থাকিলে মোক কি জানো
Statement. I will be for here, my lord. Three and four, my lord.
Sorry, the demanded is sum of rupees 15. Demanded. (23) 2023. (14) 11 2020. As well as division bench order. No, state of Nagaland and others verdicts by on 2019 5 GLT 444. Yes, in it's kind of earlier people I for my son, your lordship purpose. Yes, madam. Madam. My lord, you know. Your lordship, I will be yes. If any criminal case is also pending, if there is charge sheet also, so he has to. But today I am not brought in judgment. Your lordship also one judgment, but today I am not thinking that this is going to dispose of. So thereby, I will make some times. This is the problem. Really, I am speaking. I don't think they are. That was benefited to me. One case your lordship passed in my favor, but today I cannot. I am not thinking that today this. So this is that is why I am thinking that. Yes. Rapidly. Division bench. Then the division bench are there. If this 4-4, then not 3 months. That's why I'm saying that there's a dispute minor. If this 4-4 suspension order, no. Four four, but these 4-4, then they are not at days, minor 90 days. Yes. Yeah. You know, some other minor judges, other minor honorable single justice, the view is different. I'm going to realize if one would give the time, minor. Yes, minor, take time after 1 week, kind of place. Or not only one, so many courts in different view, minor. But thereby I'm coming division. You have to. But Milo. some problem is there in record, so that's why I'm going to
No, no,
on oath required.
My lord, whatever record I have already placed with
Why
your
you
lordship.
already about the file? Yes. Yes, ma'am.
No. We,
Yes. Your lordship pass order, well, I am going to take this one. Right. Mine.
but at the end of the day, my lord, para 22 of Ajay Chaudhary will, my lord, prevail. Once DP initiated, my lord,
That issue was in pending before the Supreme Court regarding that issue. I am going to take on. I am not going to say. I am. That's okay.
2014,
Violet.
he really made me laugh. My lord.
Violet, because of that, Violet. Because of that, this is our honey, Violet. We are in profession, Violet.
Lordship. So regarding gratuity losses, so far I remember that is correct lordship. Section 1, rules 135 is there in pension. 135 in pension measure that I have gone through earlier lordship. That is pension rules. Regarding gratuity, regarding leave encashment lordship. Leave encashment lordship regarding in pension there is not there. Might be there's a lordship notification maybe there lordship. Government notification. And but lordship, leave rules is also there lordship. Apple leave rules. Lordship. I'm really embarrassing lordship today. Really embarrassing lordship. Lordship definitely tomorrow I'll satisfy lordship. Tomorrow day after tomorrow is lordship. Pardon. Sorry lordship. Monday lordship.
My lord, let it come for 3 weeks. In the meantime, I will file some affidavit. Let me get some instructions from this, what they are doing, my lord. Because at the end of the day, it will boil down to they don't have money. This is a corporation. They were employees of Assam Government Marketing Corporation Limited. So, from the petition itself, my lord.
Tomorrow, yes, I have my time. Lordship, tomorrow I'll satisfy. Tomorrow, lordship. Yes. Right.
And 7 is how it will be determined. 7. 3 weeks, my lord.
It will be lots. Sorry, lots. Really embarrassing. The first time in my profession was embarrassing regarding provision of law. I'm really always come with preparation. Today I'm very sorry. The first time I'm embarrassing in court. Definitely tomorrow I'll satisfy in laws. Regarding the investment. Gratuity lordship, I'm saying the gratuity is half pay. That is also there. And the
Lordship, the petitioner is serving as a deputy commandant in SSB, and his wife is posted in Bihar under the Bihar Judicial Services. So on this ground, he prayed for transfer to any location near Bihar on as many as 6 occasions. And every time his
affidavit has been sent for vetting, lordship. Some more time may be done. No, lordship, already for initial 6 years, he was posted in Bihar, lordship. Thereafter, he was transferred to Assam. Again, he wants to go to Bihar. There was some administrative lordship concern therefore. Lordship, She is judicial
She's
service,
in the state government, state government category.
She is Bihar judicial service.
Lordship, if I may take your lordship, whatever affidavit they file, your lordship, that cannot be contrary to their rules, your lordship. Page 64.
Yes, sir.
Short date.
Yes, sir. Yes, sir. Add it. Three weeks, sir.
2 weeks. your lordship. Any date you transform.
May I plead the lordship? Lordship, here matter relates to non-payment of pension. Lordship, petitioner retired from Digboi College as associate professor in electronics, lordship, on lordship 31/1/2020. Lordship, therefore, his pension papers were returned by the Director of Higher Education to the principal on the ground that his service period from 1987 to 1992 shall not be counted for as qualifying service for pension, lordship. Lordship, as per the lordship, it does not fulfill Rule 31 of the pension rules. Lordship, no, lordship, it was a UGC sponsored scheme, lordship, restructuring of course in electronics, lordship. He was in that post, he was appointed. Initially, it was a UGC sponsored scheme, lordship, but it was regularized by lordship, and there is also a letter. Yes, lordship, from his date of appointment in the post on, he joined on 30/11/19. Lordship, may kindly see page 38. Page 30. All the service benefit has been given with effect from his initial date of joining. Page 38 is the order granting senior scale of pay. Here the date. Lordship. There is no regulation order, but lordship, but all the benefits has been given with effect from 30/11/1987. And all the senior scale of pay, selection grade of pay, lordship, everything, lordship. And in this respect, against the order of lordship.
There is, the principal has written to the Director of Higher Education, lordship, at page, the principal, lordship, of the
Page
Digboi
45.
College, at page 45, to review the pension case of the petitioner, lordship. Lordship, that can, yes,
Page
lordship.
45.
Lordship, that is still pending, lordship. It can be disposed of within a time frame, lordship, by the Director of Higher Education, lordship.
Last paragraph, maybe, lordship, page 46. Page 46, lordship, last paragraph. Regarding the consideration of the service period of Sri P.K. found from 30/11/1987, I would like to state you that during the time of his protection of pay as lecturer in electronics at Digboi College at the stage of ₹2,500 on 31/3/1992, as well as during the time of his placement in senior scale of pay on 30/11/1994, the whole matter was duly verified by your office and hence approved the date of approval of the service of P.K. Hound on 30/11/1987. Further, the Education Department, Government of Assam also verified the matter and hence issued no objection to grant of senior scale of pay to Sri P.K. Hound as proposed. Keeping in view the particular cited above, I would like to state you that all the service benefits of the teacher concerned should be originate from 30/11/1987. He admitted the petitioner's case, lordship, saying that his qualifying service shall be counted with effect from 30. But lordship, this post has been granted concurrence, permission, everything from 1987, lordship. Was it page 24? Page 24, annexus C. This is the government concurrent process. I am directed to say that government convey permission to the introduction of electronics subject in 3-year degree course, general standard in science stream in Digbur College, and concurrence to the affiliation of the above subject with effect from 1988, 89. Yes. But all the benefits already government has approved his, let's say, granting him all, let's say. It is a UGC scheme, let's say, it is UGC scale of pay has been given to him. It is a permanent, one of the condition of appointing him was that it post shall be created. Okay. Okay. Within a specific time frame, let's say. Artists.
DU for myself. Higher education.
Lordship. Not, not this period, Lordship. This period shall not be counted as a qualifying service. Yes, Lordship. Lordship. From 1987 to 22, 20. Lordship, they wants to, Lordship, deduct this period, 1987 to 20.
20 years, not into 28 years.
28 years. They send it back for rectification. They wants to calculate it from 1992. Lordship. Lordship. He is entitled to pension, qualifying service, Lordship.
Higher Education Department. That Lordship, there is a request to review the pension case of the petitioner, Lordship, at page 44.
You know that. No, Lordship, impugn order, for review of the impugn order, Lordship. Impugn order, Lordship. Lordship. Lordship.
Director of Higher Education, respondent number 3. Lordship.
In the meantime, pension may be released, Lordship. Pension may be released, Lordship, because he is otherwise qualified for pension. From 2020, he has not been.
Yes, Lordship.
From
Within a very short time. From 3011.
From 3011.
Thank you. One 4/1992.
One month, Lordship. 1 month, Lordship. Because it is retired 2020, he retired in January. Otherwise, Lordship, he is eligible for pension. Lordship, his eligibility for pension with effect from his joining in 1987. Lordship. Otherwise, they will take into account the 1992. Lordship.
On behalf of Architect.
For respondent number.
Respondent 5. CIN-LUN and LUN on behalf of Architect Salabda. Respondent 5.
Highly obliged. Lord.
Yes, Lord. Yeah.
All right, Lord.
All right.
Lordship, in item number 43, the respondents in Finance Department is yet to file their affidavit, my lord. On last several occasions, Lordship, They have shout line from this court in view of filing their affidavit, my lord. We have challenged the stoppage of house rent allowances, my lord, of the petitioners. The petition, my lord, they were subject teacher and assistant teacher.
Lordship. Lordship, but why the finance departments, we have not filed there's subject teachers and assistant teachers, my lord. Yes.
The respondent number 2 is the finance department, my
No,
lord.
Lordship. Yes, Lordship. So if there's no Lordship, that is exactly my point. Why the payment?
Lordship, the education department has not filed their affidavit, lordship. They have.
Yes.
Lordship D Musahar. D Musahar. Second, respondent number 1, 3 and 4, your lordship. Secondary education department, lordship. Lordship, 3 weeks here.
Oblige, your lordship.
Oblige, your lord.
Lordship, this matter may be acted on for today.
Lordship, everything has been done on the part of the tourism department on the last occasion. Lordship, it is almost 1 year. Employees Provident Fund Authority, they communicated to us to provide the bank account and other regulatory information to the, with regard to the daughters to them so that they can transfer the money. And we communicated them whether they have responded or not, that information, Lordship.
That instruction I don't have. Lordship.
We communicated to them on 8/9/2022, Lordship.
Lordship, in this case, Lordship, my instruction is Lordship, matter before the AG, Accountant General, Lordship, when a Account General is not a party here, Lordship. Problem is this.
My lord, provisional pension has been given, my lord. Date of birth, my lord.
So, आप party नहीं हो. नहीं, you are not.
My lord, page number 19, service book, my lord.
That was Lordship withdrawn.
That was withdrawn, my lord. In this case, my lord, the department released from service on in the year of 2018, my lord. 2018.
This matter was come before the Lordship Lajima Court. Sorry. Yes, no? Lokadar also lost.
Yep. My lord. My lord, kindly see the communication that is 14/6/2000. According to school certificate and my lord, the service book, my lord. My lord, 1/1/1961, my lord. Yes, my lord. Retire on, my lord, 31 31/12/2020. Well, kindly see the order dated page number 26, madam. In this issue, the honorable court granted interim order, my lord. Kindly see the page number 27, my lord. Yes, madam. Yes, ma'am.
31/12/20.
My lord, page number.
31/12.
Page number 29, my lord.
2020.
My lord, page number 29. Yes, ma'am. January. One. 1961.
61.
Yes. Area salary. My lord, which period, my lord? 31/12/2018 to 31/12/2018 to 31/12/2020. 18 to 31/12/2020. Yes, ma'am. Area salary and retirement benefit. Yes, ma'am. Area salary. Yes, ma'am. Yes, madam.
So far the area salary is concerned, I have no instruction, Lordship.
Page number. My lord, 31/12/2018 to 31/12/2020, my lord. My lord. My lord, in present case, my lord.
Lordship. And Upadhyay, Lordship. 80,
Yes, my lord.
That is the case.
Yes, my lord.
Yes.
Wrongly released, my lord. Yes. Yes, ma'am. Yes. Yes. My lord, already corrected, my lord. Kindly see the communication dated
14/6/2023, my lord. Kept in record, my lord. My lord, there is extra copy, my lord. Yes, my lord. Submitted in the local development. Communication dated 14/6/2023, my lord.
Lordship, it was totally directly submitted to the court, Lordship. So probably, Lordship, the department has accepted, Lordship. Now my instruction is it is submitted to the accountant general, Lordship. In fact, Lordship, my officer went to the office of the AG. AG accountant general says, Lordship, we are not a party in this case.
Other benefit already my lord has given, my lord. Provisional benefit has been given, my lord. Most probably.
My lord, in this matter, my lord, SEBA was directed to submit instruction regarding the age of the petitioner, my lord. My lord, after verifying the records in the SEBA, my lord, the petitioner's age as on 1/3/1979, my lord, it is found as 18 years, 8 months, 0 days, my lord. And therefore, my lord, his date of birth is 1/7/1960.
Yes, my lord. My lord, may I place my case, my lord? My lord, this case is based upon the discrepancy related to my age regarding my retirement age, my lord, because of which my pension has been withheld, pension and other pensionary benefit. Now, my lord, before my retirement, 2 years ago, my lord, before my retirement date, I get a notice from them, the parent department where I was employed, and I should retire. And then they gave me that you should retire as per this date. They told me that I should retire in the year 2020. But I told them that as per my birth, I was born on 1/7/1962. And as per that, I should retire in the year 2022. 1/7/2022, accordingly. My lord, in the year 2022.
Now, my lord, they have said that I have overstayed for a period of 2 years, because of which they have not really benefits and rupees 8,12,000 my DPF amount. My lord, the instructions today only it has been placed. One point, my lord, would kindly come to page 24, my lord, of the writ petition, if my lord kindly comes to. I retired on 1/7/2022, my lord. As per my birth. My lord would kindly come to my service. My lord. My lord, today only we have got the instruction. My lord, I had already cleared the air regarding my age of age, my lord. My age in my admit card is proper. My lord would kindly come to page 20 of the petition once, my lord. So, my lord, I need to give a reply to the instructions I have got today, my lord. I need to give a reply to the. My lord, PR sort of. My lord, no, my lord, they are to file. I need the instruction, my lord. They need to give it to me in the form. No, my lord. Reply have filed against the affidavit opposition filed by the district elementary education. My lord, the instruction placed by my senior today. This, my lord, this Seva, my lord, from Seva. They are newly elected party, my lord. My lord would.
Yes, my lord. As per SEBA record, my lord, his date of birth is 1/7/1960. Yes,
1962.
And that MRS copy, my lord, that the below page, my lord, that was provided by the school headmaster of the school concerned at the time of appearing in the SLC examination in the year 1979, my lord.
My lord, I had already cleared the air that this is erroneous, my lord.
Yes, my lord.
Also, I am for the elementary department.
Yes, my lord.
We are newly implemented.
Respondent 9, my lord. Never.
Yes, my lord. As on? Yes. Yes, ma'am.
My lord, I retired last year, my lord.
My lord. My lord, this is MRS, my lord. Manuscript register sheet, my lord. Sheet. Yes, ma'am.
Lord.
In the office record, lordship, his date of birth was 1/7/1960, as per their admit card. And
As
lordship, we have filed our affidavit. Lordship, kindly take up the affidavit filed by the director of elementary department. Running page 50, lordship. The notice was duly served on the petitioner on 1/6/2020 that he has to retire on 30 July. Lordship, kindly take up this notice, page number 66, running page number 66, Lordship. On 1/6/2020, the notice was given to the petitioner. On verification of your service
who and as per letter number so and so, dated so and so, issued by the Commission Secretary to Government of Assam, your date of retirement falls on 31/7/2020. Therefore, you are hereby intimated to hand over all the documents, papers under your possession and also deposit the government money lying with you. If any in school fund systematically to the senior most teachers in the afternoon of so and so and ongoing retirement. In addition to you are also hereby intimated to submit all the relevant papers, documents related to the pension to the district elementary education officer Golaghat as soon as possible. This notice was issued on 1/6/2020. Now, in reply to this notice, Lordship, the petitioner has given a reply on 17. Lordship, you will find in page number 69. 17/7/2020. By misleading, the petitioner said, with due respect, I beg to state that as per your office letter, I have been asked to go on retirement on 31/7/2020, but my HSLC, which my learned friend has now produced, admit card and pass certificate in all the documents in the office of my date of birth is recorded as 1/7/1962, which is false. It is a fact that my date of birth is 1/7/1962. In this regard, I have submitted an affidavit. I have hereby clarified you that the date of birth recorded in my high school certificate issued by the board is not correct. Date of birth recorded in the admit card is correct. Therefore, I request you to allow me to continue in service till 1/7/2022 and of life. There will not be any discrepancy in my date of birth, and I will be responsible for any discrepancies. This is my humble prayer.
My lord.
Now, Lordship, Lordship may kindly take up page number 71. The department has also written to the Seva asking for the clarification on the authenticity of the date of birth. This letter was written by the district elementary education to the chairman Seva. Page number 71. And 72, Lordship, Seva has then also clarified that page number 72, Lordship. As per record, with reference to your letter citation, I am directed to inform that the information regarding age of Narendra Nam Barua sought by your letter number so and so, actual date of birth is 18 years, 8 months, as on 1/3/1979.
That is my lord 1/7/1960.
Meaning thereby his date of birth is 1/7/1960.
My lord, this is as per my HSLC certificate, which is wrong, which I have already cleared the air regarding the affidavit.
My
That is what I am
certificate
saying. This is
cannot be
wrong.
wrong, my
Admit
lord.
card date is right. They are putting words into my mouth and the court mouth.
Yes.
Lord.
Fine.
On the
Therefore, in this
My
case,
lord, but I was
willfully by misleading.
My lord, I was. My lord. My lord.
Yes, my lord, we will file it.
My lord. Yes. My lord, service.
Yes, my lord.
My lord, one more thing I would like to point out. My lord, service has been completed in the instant case, my lord. My lord would kindly refer to office note dated 7/8/23, my lord, upon R7. My lord, the admission, the matter may kindly fix the admission. My lord, it is coming in ordered state, my lord. They kindly will take it. It will come up for admission.
DK Roy. Seven. Register sheet.
ठीक है
My lord, may I refer to one more point? My lord, order dated 27/9/23, my lord wants referred to. Order passed by this honorable court. My lord, this honorable court has asked us to furnish the copy of our original admit card, my lord, original one, that we had submitted, and that shows categorically that my date of birth is fixed. No, that shows 16 years, my lord, the admit card.
My lord, regarding the admit card, my lord.
That has been paid.
Yes, sir. We have elementary education department. We have already filed our application. Representative lawsuit, one lawsuit. Retirement notice.
My lord, in admission, my lord, in admission, service has been completed. Service has been completed, my lord, in admission stage. Highly appreciated. Years or months.
Third or fourth round of litigation, my lord. Third or fourth round of litigation, claim is my lord, the old pension scheme. My lord, at this hour, my lord, I don't want to say anything. They have not filed affidavit. I will pray, my lord, your lordship will take the matter for final disposal.
Also, yesterday, also yesterday only we had received the instructions. Lordship may give us some time. 3 weeks till Lordship. D.
3 weeks will be
Musahari.
too late, my lord.
D. Musahari. Secondary Education Department.
My lord, it will be, I pray, my lord. Let it come for my lord, attempt for disposal. Because all appointments, persons who were appointed, my lord, they are getting old pensions, accepting this 16. Because no, they were appointed, my lord, pursuant to the order passed by the court because they were left off. So therefore, once the process has been initiated, my lord, your lordship knows the judgment. So I'm taking benefit of the judgment only. That is the question. They are saying you are appointed in 2011. They are saying process initiated. It is because of your fault appointment was not. Oblige.
D for Delhi. D. Musahari.